Mr. Brooks, I'll provide you with the copies later on. I need to continue with the instructing of the jury and have the parties make their closing arguments.
Your Honor, with all respect, the state received copies. How come I can't receive the copies of my files?
You know what? I can give you the print-offs, but I can't give you the originals right now. That's what I'm referring to, and you will absolutely get those back. I guess I was mistaken that you wrote copy on it. I thought you retained a copy for your records. So with that, Madam Clerk will print off from the record. It won't be the yellow copies just yet. I'll take that up later outside the presence of the jury after the case has been given to them. Now, in terms of the closing arguments, I did set a time limit for the parties yesterday. Each side will have a total of 1 hour. Mr. Brooks, so that you are fully aware, the party with the burden of proof, which is the state of Wisconsin, goes first. Then you, as the opposing party, will have an opportunity to respond and argue. And then, time limit willing, the state also has the opportunity to present rebuttal because they have the burden of proof. And that is provided with the excerpt from the bench book that was provided to you yesterday. It has the purpose of the closing arguments is to summarize the facts, marshal arguments, focus the issues for the jury. I just talked about the order of the arguments.
You're right. Back at it.
The scope of the arguments.
He's not going to make it very long, I don't think.
Form of argument are within the court's.
He's made it longer than I thought already.
Limit of 1 hour for the parties. And
this guy sucks.
Mr. Brooks, I will advise you that I certainly will wait and see how you present your argument today. I will certainly wait to see if there are any objections raised.
There will be.
I also want you to be aware that if I feel the arguments are improper, I may simply, without an objection, say, please move on, as a clear indication from this court that
you're dumb.
What you are stating is not proper under the
There'll be a lot of that.
Various rules and case law that govern closing arguments.
Oh, man.
Without prejudice, I'm here by special appearance. I don't consent to being called that name for the record.
It's noted, sir. All right. Then, with that, I will.
Isn't his name Darrell Brooks?
Looks like Attorney Upper has some issues she wants to raise.
Yes, I just have one question, Your Honor. Would I have permission to put the easel up and display some of the poster boards? I did confer with Captain Dussault as far as security is concerned, and he agreed to it if the court would give me that authority.
Where would it be displayed?
He's going to put it like right here, and then you want me standing at this table during.
I do.
Yes, so I would just position it right here. And I don't have to leave it up through the whole thing. I realize it blocks the view of people in the courtroom. Detective Casey would be willing to assist me in removing them when I'm done with them, if that's okay with you.
Okay,
I trust it won't block Mr. Brooks' view of the jury, and
That's
as long
what I-
as
yeah, I was going to put it like right about here so that he could still see me and the jury.
with that caveat, yes, I will allow that.
All right.
Objection. What is that? What is supposed to be put up?
I'll allow it.
They were previously admitted, Your Honor. It's Exhibit 15 and
God, he's the worst.
130, I believe.
So are they exhibits? I'm confused to what they are.
Mr. Brooks, I've made a ruling. The state has made a request. I've granted it.
Yeah, but
In
I'm
terms
saying
of-
I don't understand what's being shown. Should not have the right to ask to object and ask what it is that's actually going to be shown.
That's why people
State
have
doesn't represent what
lawyers.
They are exhibits that have previously been received by the court during the course of this trial. Objection! For a party to do that during its closing arguments.
So can I put up exhibits?
Can I
Ms.
put?
Brooks, I don't know what you have planned for your closing argument.
I'm making a request, the same request. May I be able to put up
Well, I
exhibits?
guess it depends.
Yeah,
on
put
what
'em
it
up.
is, sir. So I'm not going to take up any more time because what I intend to do is once the state goes through its closing, I may take just a short comfort break depending on how long it is.
A comfort break.
And if there's something in particular, what are you will need to tell me what it is. As long as it's an exhibit from this case, then I wouldn't have an issue with it.
They would be from this case, obviously. It's just not nothing that the state has.
I'm not aware of exhibits that the state wouldn't have, that you would have. Everything that's been received, we have a list. So if it's not something that was received during this trial as an exhibit by the court, unless you tell me what it is so that I can make a ruling, I can't see how it would be relevant or appropriate for your closing argument.
They're part of my filings that you filed.
The filings have no relevance to the issues that are before the jury. The closing arguments are to direct the jury so that they have your
And once again,
argument,
this is why
so that
people
when
have
they go back
lawyers.
to determine the issues
He's an
in
idiot.
this case, which are related to whether you're guilty or not guilty of the 76
He's guilty.
charges.
Lock him up.
Things like subject matter jurisdiction or like that would not be something that would be proper before this jury. Those are legal issues that the court would decide. The jury is the judge of the facts. The court is the judge of the law. That's why I have all of these jury instructions to give to the jury.
I'm not referring to subject matter jurisdiction.
What are you referring to then? Be very specific so I can make a finding and ruling.
I was specific, my other filings that
That's
was
not
filed.
specific enough, sir. What are you
My
referring
court
to?
docket
Which
sheet.
filing?
Let me know when you're done, Your Honor.
Which filing, sir? Not generally, but specifically.
Are you done?
He's going to get kicked out.
Are you done?
Sir, that's very rude and
No,
disrespectful.
I didn't know if you was finna say something.
I
That's why I'm
paused.
asking, are you done?
What filing
Your Honor,
are
how
you
come
referring
every
to?
time I try, even when I try to err on the side of caution, you find something to be something that it's not? I didn't know it was something else.
I've asked a question, sir, so when I do that, I would hope it would convey to you I'm looking for an answer. So which filing are you referring to?
All
With
my
specificity.
filings, my notice of appearance, my statement of particulars, my bond, the court docket sheet, all of those filings.
The request to display those to the jury is denied. It's not relevant.
Bam!
Relevant, not even your
That's my
oath of office.
determination, sir, so I'll take...
Denied!
I'm going to start this.
Not
Get
even
outta
your
here.
oath of office can be shown.
No, that is not relevant to these proceedings, sir.
It
Send
is.
him back.
It's not relevant in front of the jury.
Why is it not relevant? Can you
Mr. Brooks, you
explain
are
why
not
that's
going
not
to
relevant?
be able to raise those types of issues and present a closing argument based upon my oath of office, whether I'm licensed to practice law in the state of Wisconsin.
I said your oath
whether
of
there's
office.
subject
I didn't
matter
say anything.
jurisdiction, whether you consent to this appearance or not. None of those things help the jury determine the issues in this case, which are related to whether you are guilty or not guilty of the 76 charges that have
The
been
jury
filed
should
in
know
this
that
case.
they should know the truth in their duties, in their rights.
Oh,
They should
no.
know that at
He's
least.
going to get kicked out.
Mr. Brooks, I'm putting you on notice that if you continue with this insistence upon presenting information that's not properly before the jury as evidence in this case,
He's going to get kicked
that
out big time.
I will instruct you during your closing argument to move on and potentially ask the jury, have the jury leave so that I can admonish you.
Kick
And
him out!
Keep insisting on that, sir. That will be in direct violation of the court's direction
So
to
they
you.
can't even know that I got a shock device on my ankles.
They absolutely do not need to know that.
Why
so it's
not?
not relevant to the determinations of guilt or innocence.
It's the truth.
Mr. Brooks, your custodial status is not on trial here.
I will
No,
argue that it
your
is.
conduct from November 21st of 2021 is what
That
is
hasn't
on
been
trial.
proven.
You may not bring up the way that you've been shackled. It's not relevant, sir.
It's
and if
the
you
truth.
do so, you do it at your peril. But here's the
There
thing:
is
the
no
jury
peril.
is specific.
It's my right,
No,
though.
Let me go. Okay.
It's my constitutional
is-
right. Just
No,
like
it's not.
under the First
Things
Amendment,
that
which I
you're-
preserved my First Amendment right when I came in this morning. I also preserved
I don't think
my
the
Sixth
jury's
Amendment
present yet.
right.
Please stop. You do not have an unfettered First Amendment right. That is very clear based upon
What do you
all
mean
the
by
case law.
unfettered? What do you mean by unfettered?
It means it is not absolute. It can be restricted.
So the Constitution of the United States can be constricted.
All right, Mr. Brooks, I'm putting you on notice that if you continue with your insistence on raising issues that are
I'm going to
merely a
raise issues that the jury needs
that
to
are-
know.
They're not
Regardless,
issues.
because they're under the rights of the United States Constitution, which
Mr.
is
Brooks,
the law
I
of the
direct your
land.
attention to closing instruction 460.
I'm
which will be read
going
the
to
jury
let the
at some
jury
point.
know the truth, their duty and their rights. Under the First Amendment and under
Wow.
the Sixth Amendment, I have the right to inform them of their rights, of the truth, and of their duties. Under the First Amendment and under the Sixth Amendment of the Constitution of these United States. You can't, no state law can override that.
Mr.
Any
Brooks,
law,
do you intend
any
to
law
keep this up when the
repugnant.
jury comes out?
Your Honor.
Because I need to
No, I
have
do
the
not. That's
state-
why I'm addressing this before
not-
they come out. That's why I'm trying to address this before they come out, so it doesn't become an issue once they're in here.
Just do it when they
But
come
under
out
the
then,
First
dummy.
Amendment and under the Sixth Amendment of the Constitution, which are rights that I preserved the moment we stepped in here this morning when this proceedings started. I preserved those rights for the record. And now you're telling me that those rights are not, would you say unfettered or, I don't know what you say. I don't even know what that means. I don't even understand that. But
Shocker.
any law repugnant of the United States Constitution is null and void.
Repugnant, null and void.
Mr. Brooks, I'm putting you on notice. that
Null
you
and
also,
void.
Forfeit by your conduct the right to present a closing argument.
It's null and
In
void,
appropriate
dude. Come on.
circumstances, the right to present a closing argument, no different than the right to testify, may be subject to forfeiture where your conduct is incompatible
Null
with
and
the assertion of the
null
right
and void.
at issue. The goals that this court has attempted to follow throughout this proceeding are multifaceted and multifold. Number one, I do have an obligation and I have done my best to ensure that this is a fair trial. However, a fair trial does not mean a defendant has unfettered rights to state whatever he wants when he wants. This court, not only through the course of the trial, is deemed with the responsibility to control the presentation of evidence so as to ensure fairness and reliability of the criminal trial process.
This is going to get good.
It also includes
Or bad, really.
Ensuring that the closing arguments are relevant, are appropriate. This court must also be concerned with efficiency and effectiveness, and of course, last but not least, courtesy and decorum in this courtroom, what I would generally refer to as civility in the courtroom.
If you're here watching, hit that like button,
Do not
please.
have unfettered First Amendment rights or an unfettered Sixth Amendment right, sir. You must conform your conduct to the rules of decorum, the rules of evidence, and the rules
Decorum?
of procedure. While you have a right to present relevant and probative arguments to this jury, you may not present arguments related to such things as jury nullification, subject matter jurisdiction, the court's oath or lack thereof, if that's what you believe, whether this court is a court of common law, admiralty, all of those things relate to your claim as being a sovereign, which are frankly baseless. They're meritless. They've been debunked by many courts, including the court in the Beneby decision that's been referenced by this court
He's a sovereign
previously.
citizen. First Amendment auditor.
Opportunity to present a closing
Your Honor, I'm a
argument,
First
but again,
Amendment
it is
auditor-
not
auditor.
unfettered. The simple
That's basically
fact
what he is.
sir, this court can restrict your right to present a closing argument. This court has the authority under 906.11, under the various cases, including Illinois versus Allen, including Rock versus Arkansas, although Rock versus Arkansas and Chambers versus Mississippi dealt with the right to testify. There is a decision, I looked it up earlier, and I'll just pull it up and tell you the case site so that you have it. I would direct your attention to Herring versus New York, found at 422.
She's she's explaining her
853,
decisions to him,
1975
which
case, although in a footnote,
she's just trying to be thorough,
it
but
does
it's
state
annoying.
the proposition that a defendant who has exercised the right to conduct his own defense has, of course, the same right to make a closing argument. That's quoting State Ferretta versus California, or following the same logic from Rock and Anthony and Chambers, a right, even a constitutional right that a defendant has may be forfeited by conduct. This court, just like it attempted to do with regard to your right to testify and set up reasonable restrictions so as to meet all of the goals that the court needs to meet, will be as follows, and that is, again, sir, you may not bring up matters that are not.
Oh, yeah, I can't wait till he gets
determination of
sentenced.
Guilt or innocence. That means evidence that was not presented and not received in this courtroom is not relevant to your closing arguments. It's not. The arguments must be based on the law, not as you interpret the law, but as the law is. You must base your closing arguments on the facts that have been established during this case, meaning the evidence, the testimony. As I indicated earlier, the purpose of a closing argument is to summarize the facts, marshal arguments, and focus the issues for the jury. It is fair that you comment on evidence, including arguing evidence to the conclusion or inference. It is your ability or your opportunity to convince the jury that you are not guilty of these offenses.
Guilty.
You do not convey any idea that you have undisclosed information.
Guilty.
Neither party may vouch for a witness or otherwise express personal belief or opinion
Guilty.
regarding truth or falsity of any testimony or evidence.
Your Honor, he's guilty.
It would be improper to ask a jury to draw inferences that the parties know are not true.
The state rests.
And your comments on evidence is limited to evidence in the case. You may not comment on facts outside the record or peculiarly within your own knowledge.
Guilty.
And that is just some of the guidelines for determining the proprietary of arguments that I am guided by from my judicial bench book and all of the cases that are referenced therein. So you are put on notice, sir, that even without an objection, this court may, in an effort to preserve the dignity, the decorum, and to keep the issues properly before the jury, may advise you during your closing argument to move on. If you do not honor the court's rulings, then you will run the risk of forfeiting your right to be present and potentially forfeiting your right to further present.
You know what she wants to say. If you do that, I'm going to kick you in the sack.
I am bringing this jury out to complete
Bring
the
the jury
instructions
out.
that I need to complete.
Bring
to
'em out.
Add to the credibility instruction, the paragraph on implicit bias. And to
Okay, so when the jury comes out, how long do you think he makes it? How long do you think they let him stay in the courtroom?
parties, and then to
I say 10 minutes
first as they bear
at best, probably
Just
less.
let you make your record. I didn't overtalk you. I didn't interrupt you.
Overtalk you. That's
Is
good.
that fair to say? I let you make the record. With all due respect, when will I be able to make the record? As I've tried to do numerous times by saying I wanted to present an offer of proof for my appeal. That's the chance for me to be able to make the record.
I'm denying your request to make an offer of proof regarding your appeal. It's
So,
not. I am
I'm
not
not allowed to
required
make the
to give
record
you
at
that
all, Your Honor?
opportunity, sir.
I'm not allowed
Sir,
to make the record at all. As I just let you did, because some of the
Sir,
issues
I
has
have.
been some
You
of the
have
issues
told me
has
what
been
you want to do. I've
Your
told
Honor.
you you can't. I've addressed
Your
the
Honor,
request.
some of the issues have been me over talking you and interrupting you. I did not do that. Even though everything that you said, you have not proven for the record, and is unlawful law. You haven't shown one time that that's that it's lawful for you to do what you've been doing.
Oh, it's
as far as
lawful,
your
baby.
rulings.
Once again, I'm not going to debate with you the prior rulings of this court. There's absolutely no need at this point for you to make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you
I'm
will have an
going to
opportunity,
inform-
if
I'm going
convicted,
to inform the
raise
jury.
every issue.
Uh-oh. Are they going to cut? Are they cutting me off? Are they going to cut me off? What are they doing here? I mean, are they going to kill the stream? Are you going to kill the stream or what? You don't own this trial. What the hell's going on? Can you guys still hear me? Am I still on the screen? Okay, good. What happened? Let's see. Does it happen in other places too? What's going on? Still with you.
Point for you to
Your
make an
Honor.
offer of proof regarding.
Let me see.
Regarding my prior rulings or decisions that you disagree with.
Your Honor,
you
I'm
will have an
going to
opportunity,
inform-
if
I'm going
convicted,
to inform the
raise
jury.
every issue.
Great. We were chilling earlier.
I let you make the record. I didn't interrupt you not one time.
No, but sir, you're attempting to disrupt the proceedings by
I'm
going
not
off on a
attempting to
tangent
disrupt
into
anything.
all of these other issues.
How-
From my
how am I-
perspective, that is in an
How am I
attempt
being
to
dishonored?
simply
How am I
delay
being in
what we're
dishonor?
doing.
How am
So
I being
you are
in
put
dis-
point for you to
Your
make an
Honor.
offer of proof regarding my prior rulings or decisions that you disagree with.
Your Honor,
you
I'm
will have an
going to
opportunity,
inform-
if
I'm going
convicted,
to inform the
raise
jury.
every issue.
What the hell is going on here?
By a blatant disregard for the parameters that I've set up, you will forfeit your right to be present in this courtroom and potentially forfeit your right to present a closing argument.
Under what lawful law can you do that?
Sir, I've
You
made
can
my
you can hold me in
determination.
contempt by Illinois versus Allen. You can do that. You stated that numerous times.
Mr. Brooks, I want you here for the closing arguments,
Apparently
but
you
do
don't.
not want
Apparently
to
you
follow
don't,
the
Your Honor,
rules.
because all I said was It is my right under the First Amendment and the Sixth Amendment to inform the jury of the truth, their rights, and their duties. I never once said anything about, oh, I'm going to bring up subject matter, or I'm going to bring
You're
up
right,
this,
sir. And
or I'm
I
going to
will
bring
wait
up
and
that.
see what you have to say, but I thought it prudent, given your conduct to date and your insistence on bringing up issues that have no bearing in this case.
This is a new
They're not
day, though, Your
relevant.
Honor. This
They're
is a
not-
whole new day.
That it was prudent.
I'm
on
worried
my
Court
part
TV is
to
gonna,
give some guidance before you potentially
cut me off, but
do that in
whatever.
front of the jury. But
Okay,
you're right.
but-
I will wait and see.
Your Honor, it's
But
still,
I need to get going.
it's still
and I'm going to,
unconstitutional for
sir.
you to
So
tell me that
you
I don't
need to
have
be
the First
quiet.
Amendment right that I preserved, or the Sixth
Mr.
Amendment
Brooks,
right
I'm
that I
going to have
preserved.
the jury brought out. I expect that you will be respectful,
Come
courteous,
on.
and quiet.
Or I'll be
And when
held
this
in
door
contempt.
opens,
Or I'll be held in
if
contempt.
you insist on making remarks, then I will excuse everyone from this courtroom, and you will be removed because you will forfeit your right to be present for being disruptive.
Under what lawful law?
That
Because
is
I
my
haven't been
ruling.
dishonorable to the court.
The
under what lawful law?
jury brought out.
Well, take me to the next courtroom then. Take me to the next courtroom, because you're not going to override my constitutional rights just because you feel like you can, and you don't have no lawful law to do that. We all have constitutional rights, and you cannot trample
Mr.
on
Brooks,
those.
what you are raising are essentially issues that you can raise on appeal.
No, I'm raising them now because they need to be on the record now. Because you won't allow me to make the record as I've let you do. You've even went so far as to mute
Mr.
me,
Brooks, the
which you
jury
can't
is
even.
coming
There's no
out.
lawful law to say that you
I'm
can even
advising
mute
you
me.
to be quiet. They're coming
Your Honor,
out.
does Illinois versus Allen say that you can utilize the mute button? It does not.
Mr. Brooks,
So
when
you're-
the door
you're-
opens, I expect you to be quiet.
You're,
and you will
you're,
forfeit
and I
your right
expect
to
for
be
you to,
present.
Here we go.
answer questions as a public servant. Your Honor. You're a public servant.
jury's coming
You're
in.
supposed to serve the people.
All right.
Take me to the next courtroom.
Oh
Take
no!
me to the next courtroom. Hold me in contempt. Hold me in contempt. Hold me in
Uh-oh.
contempt.
She's pissed.
Hold me in contempt.
She's pissed.
I have constitutional rights that are being trampled on.
You have a constitutional
You're
right
coming
to
up
shut
with
the hell
ways
up.
To make a lawful law where it doesn't say in Illinois versus Allen anywhere about utilizing the
Records
mute button.
reflect that the jury bailiff is in here. However, the jury is still in the hallway. I'm going to give Mr. Brooks one more opportunity to be respectful of the court's rulings, whether
Your Honor,
he
I
agrees
haven't-
with them
I
or
haven't
not.
dishonored the court. I'm merely exercising my rights under the Constitution, under
we
the
go.
First Amendment, and under the Sixth Amendment.
Mr. Brooks, your rights do not include you disrupting these proceedings
I'm not,
the way
I'm
that
not
you have
disrupting
through
the
the course
proceeding. You
of
just
3
told me
weeks.
you don't have to honor my constitutional rights in so many words. You're using a mute button
Mr.
that's
Brooks,
not
the
even in your
jury is
decision.
outside this door. They're not brought in
I'm
yet.
informed that
I'm
the jury. I'm
asking
informed
you
that the jury
to
is
be
outside the
respectful
door.
of their time.
They're not in the courtroom.
Use
They're
the
not
shocker.
present.
Be respectful of the court's
They're
whether
not
you
present.
agree with
These
it
are
or
issues
not.
that need to be resolved before they're present.
Mr. Brooks, they will not be resolved to your satisfaction.
It's not about my
The
satisfaction.
record
It's
has
about the
been made.
Constitution. It's about what's right.
Are you
That's
going
right.
to
Are you going to
follow the
answer
court's
questions as a public
requirement?
servant on why you're making up laws that are not in the Illinois versus Allen? It never utilized
the
the
jury
mute button.
can
It
go
never
back
said
to the
anything
jury
about a
room.
mute
Thank you.
button.
It is clear
Why
that
am I
Mr.
being
Brooks has
muted?
absolutely no intention of following the simple rules of decorum
Uh-oh.
and courtesy.
So he didn't even make
Repeatedly
it.
talked over me. He's repeatedly interrupted. Even though I've made rulings, he's not respectful of the fact that I made a ruling, even though he disagrees with it.
How can you
I
make
attempted
it?
to bring the jury out,
How can you
and
utilize
Son of a
he
gun.
continued to talk.
Brooks,
So, Mr. Brooks, you
Your
have
Honor,
forfeited your right to
is
be
that-
present for the state's
Is that
closing
not,
argument.
Your Honor?
You will
Can
be
you answer
taken
this
to
question?
the courtroom next
As a
door, and I
public
will
servant,
invite you back over when it's time for your
You can't
closing
invite me
arguments.
back over. I can reclaim my right. So how can you invite me
All
to
right,
do
the
anything?
courtroom is to be cleared so that Mr. Brooks can be removed to the next courtroom, and I'll make appropriate findings when he's in the other
Yeah,
courtroom when I
and
can
you'll
do
mute
so
me, which you
without
can't lawfully do.
interruption.
You can't lawfully mute me.
you can lawfully do it.
So now you're trampling over my First Amendment right.
Oh no! Why do they keep doing that? Did that other channel ever go back up or what? Let me see. No lawful law. There's no lawful law. There's no lawful law. So what? Are they hog tying them or what are they doing? What are they doing? He wants to tell everybody he's got a shock collar on. I don't think, I don't know. I kind of wonder if that's like his whole thing. Like, oh, you know, I represented myself and I didn't know what I was doing. So I think that that's what he's really going for here, is that he wants to be like, look, I don't know what I was doing. He wants to be held in contempt for some reason. And I know that people are saying, well, you know, if he's held in contempt, it shows a bias. But I just don't see it showing a bias. I see it showing that he's literally out of control. He's out of control and he's wasting time and he's stretching this out and he's making it, you know, worse and worse and worse and worse and worse. Because he's a dick. Excuse my language. In a big way. He's a big loser dick. Really pisses me off, dude. Like, he couldn't even get through. Couldn't even get the jury seated with. I knew that was going to happen. I said 10 minutes. He didn't get 1 minute. Out of order. I'll show you out of order. I do too. I do too. Yeah, I'm sure he wants a mistrial. He's a piece of crap. And I do feel sorry for the victims and the victims' families, and it's all bad. I hope he gets his objection sign again. That would be awesome. The objection sign? Big fan of the objection sign. Let me see. Where's my phone? There it is. I'm gonna make the objection sign because we're gonna. Objection. We're going to get this thing lit here in a second. We're going to get this thing lit. Oh, this is going to be good. Bring them back. There's so many stop and goes with this. It's horrendous. God dang it. Bring them back, baby. Bring them back out. No, there's zero flow to this, which is what he wants. You know, that's his thing. But don't worry, I'm here with you guys. Whoever wants to be, I'm here. I'll try and keep the flow going. We're back. Oh, he's in the other room. Oh, that's awesome. He's such a piece. He's back, baby. There we go. Pew. Oh, what? Come on. He's arguing with somebody. You ready? Yes, Your Honor, I'm ready. He's really an embarrassment to his entire family. You guys are going to love this. I don't know if you'll love it, but you'll like it. I don't know. Maybe you won't. Who knows? All right. There we go. Get this one off. Yeah, I agree. Yes. Order of the court. He's such a dummy. Objection. Fucking loser. Here, let me see. Here, just put it right here. Go to your corner, Mr. Brooks. We object to you being here. We object to you being here. Here, cover the Court TV logo for me. No, I'm just kidding. Shout out.
I need it quiet in the courtroom, please. We are back on the record. Appearances are as they were before, except that Mr. Brooks has been removed to the other courtroom. The court did that because we came out on the record at 2 o'clock following the lunch break. Mr. Brooks was brought to the main courtroom, and during that almost 35 minutes or so, he was insistent on raising a variety of legal issues with which this court has either previously addressed or which are meritless and do not warrant any further response. He is insistent on making a record and an offer of proof. This would not be the appropriate procedural mechanism, meaning an offer of proof at this time. We are not in the midst of a trial where the court's made an evidentiary ruling that would require the preservation of the record by making an offer of proof. This court has been attempting, frankly, all day to get through the reading of jury instructions, to get to the point where the parties make their closing arguments, and ultimately to put this case in the jury's hands. It has been challenging. It has been met by resistance from Mr. Brooks. I would once again describe it as being stubbornly defiant, although at times he may wait for me to make my ruling. He continues to not respect the the fact that a ruling has been made, and he wants to argue and re-argue and re-argue points that this court has already gone over. And in an effort to simply put him on notice regarding his behavior, given the history of this case, the court was attempting to set some parameters regarding closing arguments so that they are focused, so that they are proper, and that they follow the law. That was met with a considerable amount of resistance and repeated statements by Mr. Brooks that he has First Amendment rights, Sixth Amendment rights, 14th Amendment rights. He has all of those rights. That is not in dispute. But those rights do not come in a vacuum when we are in a court proceeding and a trial such as this. The rules of evidence, the rules of procedure, the rules of courtesy and decorum all apply. And this case has demonstrated that a stubbornly defiant defendant can forfeit even important constitutional rights by conduct.
Sure.
That includes the right to be present. It included the right to present further witnesses and testimony, and it included the right of the defendant to testify on his own behalf. I hope that I do not have to go through a decision that forfeits his right, or that makes a finding that he's forfeited his right to make a closing argument. I will certainly wait and see how that goes. I would note he was very respectful when he did his opening statement.
No, he wasn't.
It was clear. He made a variety of points.
No, he didn't.
He did so in a way that I would say was very conscientious of people's time.
No, he
It was
didn't.
cogent.
No, he wasn't.
It was concise. It was probably about 35 minutes. I may be off a little bit, but that's what my memory is. It wasn't overly lengthy. I would hope that he follows some of those same things here when he does his closing argument. But
He won't.
He has been removed from this courtroom because of his stubborn defiance and disrespect of this court, of courtesy and decorum. And what I truly believe is an effort on his part to continue to delay and lengthen these proceedings. I've said it before, I'll state it again. It is essential to the proper administration of criminal justice that dignity, order, and decorum be the hallmarks of all court proceedings in our country. The flagrant disregard in the courtroom of elementary standards of proper conduct should not and cannot be tolerated. And trial courts and trial judges that are confronted with disruptive, contemptuous, stubbornly defiant defendants must be given sufficient discretion to meet the circumstances of each case. No one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. They noted 3 constitutionally permissible ways to handle such a stubbornly defiant defendant. But they also indicated that no one formula for maintaining the appropriate courtroom atmosphere will be best in all situations. I've noted this before. This is a case from 1970. The technology that we now have in this brand new courtroom was not available then. I have the ability to have Mr. Brooks appear from the other courtroom by way of audio and visual means. We can see him, he can see us. I've confirmed prior to calling the case that the audio was working, that the video is working. The one camera, there's 4 cameras in my courtroom, there's 4 cameras in his courtroom. However, it is set to 1 camera since...
Hold on. I think the other one's back up.
Although he has lost his right to be present in this courtroom, he can reclaim the right to be present as soon as he is willing to conduct himself consistently with the decorum and respect inherent in the concepts of courts and judicial proceedings. That includes not interrupting the court. That includes respecting when the court renders a decision by way of an oral ruling, even if he disagrees with it. So with that, I will advise him that once the jury is brought out, I will unmute him. I expect that he will be respectful of them, and I expect that he will not interrupt as the court goes through the couple of final jury instructions I need to go through, including the reading of jury instruction 160, closing arguments of the parties. And then I will turn it over to the state, but I will unmute him at that point, so should he have an objection, he will be able to state objection. I will be able to rule on it. And again, I expect him to honor whatever the ruling that is made. And if he does not do that, then I will utilize the mute function. If he doesn't have it, we'll make sure he has the objection sign. And if I see that, I will unmute him to hear what it is and then make a ruling accordingly. Attorney Hopper.
Your Honor, two quick things. Please, could you confirm that the audio and video are working in the next courtroom? And the clerk's shaking your head. They've done that. Thank you. I don't know if you want to do it now or at a later time, but I think we should make a record, as I will be displaying a PowerPoint during my closing argument, throughout my closing argument, and I'm not sure how that is projected in the next room or how it affects what we see in this room, Your Honor, but we should make a record of that at some point.
Thank you. My understanding is Madam Clerk has the ability so that is displayed not only here but in the neighboring courtroom. If you would be so kind as when you start displaying it, just make some type of record, excuse me, so that the bailiff who's over there, if it's not being properly viewable, if it's not viewable, that we can stop and adjust accordingly.
Okay. Thank you.
If you would like, before the jury comes out, we could do a test.
Yes, could we please?
Please. Madam Clerk, would you confirm with the clerk over there that the PowerPoint is also viewable?
They can see it.
All right, and it should be similarly to what we see. So the monitors will display the camera that Mr. Brooks is appearing, that is on Mr. Brooks on the left-hand side of the TV, and then the 4 cameras for this courtroom are on the right-hand side, but it's probably maybe a quarter to a third of the screen, and then the remainder of the screen is the PowerPoint. The monitors in the courtroom that Mr. Brooks is in are no different than what they are here. He would have one at the table, but there would also be the very, very large TV monitor above the clerk over there. Well, it's smaller, and then the very large one over the witness stand. So it would be very similar to what is here if he were present in this courtroom.
But he's not.
I know that the diagram, it's probably not the most easily seen from a camera, but it's really no different than what I'm looking at the moment. So I appreciate you asking that I make a record of that. I would further make a record that there are headphones on the table where Mr. Brooks is currently standing. He has not put them on, but they are available.
Have you seen my baseball?
All right, then are you turning off the, all right, PowerPoint? Let us know when you need that function, and then Madam Clerk will be able to make that viewable in both courtrooms.
Yeah.
Very good, thank you.
All right, with that, the jury is to be brought out.
Objection to that as well.
Okay.
All rise. Where's my gavel? You're out of order.
All rise for the jury, please.
You're out of order. All rise for the jury.
Thank you, everyone. Please be seated. Ladies and gentlemen of the jury, when I read the jury instruction to you previously regarding credibility, I had a prior version of the jury instruction. Now, what I read to you at the very beginning of this case was the most recent. I am going to read a short paragraph, but also tell you that in the packet that will be sent with the jurors to the jury deliberation room, it will have the complete instruction, and it's instruction number 300, And this is what I want you to know about credibility. In your determination of credibility, you must avoid any and all bias based on the witness's race, national origin, religion, age, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic.
What about being an asshole?
Consider carefully the closing arguments of the parties.
Yes.
But their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given you by the court. With that, I will ask Attorney Opper to start with her closing argument. Go ahead.
Thank you. And Madam Clerk, if you would please turn on the PowerPoint.
Yes.
That cough, man. Somebody's got to get that checked out.
Hold
That's
on
some
one
nasty
second.
stuff.
Mr. Brooks, do you have an objection?
Yes.
Nothing.
I thought I was supposed to be unmuted.
You are now.
We're on an objection.
All right. Attorney Opper, you may start.
Thank you, Judge. Good afternoon, everybody. It's kind of nice to stand here in the middle of the courtroom. You know, all week or the last 3 weeks, they shoved me at the end of the table because I'm the lefty in the group. It's nice to be able to look at you all and say thank you. Truly thank you. Each and every one of you. I want to express our sincere gratitude from the prosecution team, myself, Deputy District Attorney Leslie Basie, Assistant District Attorney Zach Woodchow. There's no one in this courtroom that does not realize the sacrifice that you've made serving your community in this very important task. You've put your lives on hold. I don't even want to hear from your bosses. Thank you. You've watched these proceedings and you've noticed as we sit at our prosecution table, we don't have a client at our table. But rest assured, we do represent someone. We represent the people of the state of Wisconsin. It's an entity. I can't bring it to the courtroom. People enact laws. People want to feel safe. People have representatives in Madison or Washington, D.C. that set standards, rules that we all are expected to live by. And when those rules are violated, prosecutors step in and enforce the law. Darrell Brooks does not represent anybody. He does not have a client. Darrell Brooks is the client. Darrell Brooks is the defendant. The state of Wisconsin is the plaintiff. It's really that simple. And it's consistent with any other criminal case you've ever heard about at any other time in any other jurisdiction. It runs the same, no matter what state or federal. I'm going to ask you for your guilty vote at the end of my comments. It's up to you. I can't tell you to do anything, except I'm going to say one thing to you that I wholeheartedly ask you to obey.
Attorney Opper, I'm sorry for the interruption. Your objection, sir?
Mischaracterization of who I am and the way it was said. I feel like He was talking down.
All right, your objection's noted. It's overruled. The state may continue.
Overruled.
You must not consider anything about Darrell Brooks other than his conduct in downtown Waukesha on the evening of November 21, 2021. Nothing he's done before that, nothing he's done since that. When you go back to that deliberation room, please obey Judge Doro. Confine your comments to his conduct on November 21 of 21. Is he guilty of the 76 counts that he's been charged with? That and solely that should be your topic of discussion. So, what are the charges against Darrell Brooks?
Uh-oh.
Thank you for your patience
I can
in
feel
listening to the jury instructions.
I can feel an
They
objection
must
coming.
be read for each and every
I can
count.
feel it.
But sadly, they can be summarized very quickly like this as far as the actual counts. Counts 1 through 6 are first-degree intentional homicide
Yeah.
while armed with a dangerous weapon.
Exactly.
Counts 7 through 67, first-degree recklessly endangering safety while armed with a dangerous weapon. Counts 68 through 74, hit and run causing death. Counts 75 and 76, bail jumping, and count 77, battery.
Whoa, whoa, whoa.
Mr. Brooks, what is your objection?
I have 76 charges, not 77. It's a mischaracterization of the charges.
That is correct. It is sustained. It should be count 68 through 73, I believe, and then
Good.
74 through 75, and then 76.
Got him.
Thank you, Your Honor. I do apologize. for my
Sustained.
math skills. 68 through 73.
I don't have 1,380. I have
I
1,379.
apologize for that misstatement. We're going to talk about counts 1 through 67 in detail.
Oh, man.
Counts 68 through 73, hit
Yeah.
and run causing
Huge
death,
difference, dummy.
in my opinion, are easily summarized as this. He never stopped.
Nope.
Never. Bail jumping, he is out on bail for 2 files in Milwaukee County facing felony charges there.
Uh-oh. I feel an objection coming.
He was ordered to not commit any further crimes.
I feel an objection.
If you believe he was involved in any of the conduct charging counts 1 through 67, you should find him guilty of bail jumping.
We do.
Battery, that relates to the split lip and black eye suffered by Erica Peterson.
Unreal.
We told the story kind of backwards. We started with the battery for background. First degree intentional homicide. You've seen this in our opening statement. You've heard it from Judge Doro.
Where's the objection?
Did Darrell Brooks cause the death of the victim, a victim? Did he act with intent to kill, meaning either the mental purpose to take the life of another or was aware that his conduct was practically certain to cause the death of another human
I can
being?
feel it, yeah.
Count 1, Ginny Sorensen. Count 2, Lee Owen. Count 3, Tamara Durand.
Well, I got
Count 4, Jane Kulik. Count 5, Bill Hospital. Count 6, Jackson Sparks.
Not
Those
to
are
be
the
confused with
individuals
Bubba Sparks.
who lost their lives because of the conduct of Darrell Brooks. From there we go to reckless endangering safety. What is that? In this case, it means that through his reckless driving, he endangered the safety of other people. And he did so demonstrating utter disregard for human life. Now, Behind me is State's Exhibit 15. It's also on the PowerPoint.
It's on the PowerPoint, baby.
If you choose, you may have this chart with you in the deliberation room to help
You like how he's
walk
peeking out.
through each of these counts if you find it helpful. It's up to you. If you don't want it, you don't have to have it.
You don't have
But
to.
It will be available for you if you ask for it.
Exactly. You're welcome.
And it'll take you, as we did in our presentation of the case, right down Main Street and address all the counts that were involved, all the counts that were charged.
Okay.
To prove reckless endangering safety, and I'm just going to go back one slide, nowhere do you see there that we have to prove any degree of injury to anyone. Never once did Judge Darrell instruct you that somebody has to be physically injured. Now, Detective Casey told you that was the standard we used in deciding of all these hundreds of thousands of people who is included in these charges. And a decision was made by the prosecution team to include people who were physically injured to be efficient in our prosecution. And so everybody up and down the street, I would argue, had their safety endangered that day.
I agree.
I didn't charge 5,000 counts.
Should have.
We selected 61 counts of people that we can identify by name in Exhibit 15 that were injured by the conduct of Mr. Brooks. Those are the people in green. People in red are the fatalities. And we presented this case to you in much the same fashion that is presented here on Exhibit 15 as to how the injuries occurred going down that street. So we are absolutely held to our burden of proof and the elements for each offense that Judge Darrell instructed you on, but we are not required to prove any injury to anybody. The question is, was their safety endangered by his reckless conduct, his reckless driving?
Yes.
Now,
Oh, man. I can
some
feel.
of the groups, it's pretty easy. They walked in a formation, and you can get a photograph or a diagram, and you can kind of see pretty easily who was located where, right? And you can think back to the videos that you've seen for each of these groups and remember, and you'll see them again, the path of the vehicle as it went through each of these groups. This is South Band, of course. All of these names that are being displayed on the PowerPoint Exhibit 21 are on Exhibit 15 in green for Waukesha South Band. Pretty much the whole left half of the formation was endangered by the safety of Darrell Brooks driving up the side of that band.
Who's Darrell Brooks?
The Extreme Dance Team. It's a little difficult to read, but again, this chart was marked as an exhibit. It's exhibit number 33. If you want it, you can have it in the jury room. The names on this chart will match the names for the Extreme Dance Team on State's Exhibit 15. All of the girls that were struck and injured as they marched with the Extreme Dance Team, plus some people on the back that were handing out candy or serving in support roles as the unit made its way down the street. The Dancing Grannies, State's Exhibit 54, the formation that they marched in, who was located where, and your recollection of how that SUV zigzagged through that group. And you can just see the names and match it up to who was injured and killed versus who wasn't.
Like, could you imagine if they found him not guilty? I'm sure they won't, but
Now, one of the big things in this case has always been, why did this happen? What was he thinking? Why did he do this? Again, those are things I don't necessarily have to prove to you. His intent, I do have to prove, and I submit without any doubt there's overwhelming evidence that this was an intentional act by Darrell Brooks and an act of utter disregard for human life. I say that for these reasons, folks. Number one, first and foremost, just stop driving. That's it. It's really that simple. Not one person had to be hurt that day if he would have just stopped driving.
Excuse me, Attorney Hopper, your objection, sir?
You specifically, I'm sorry, can I be heard?
Your objection, sir?
I didn't know if I was on mute or not.
You're not?
You specifically said in your jury instructions that intent cannot be, you can't look into someone's mind, I think is what it says, to find intent. So how could that be characterized as someone knowing for sure intent or not knowing for sure intent?
You're making an argument. You'll have an opportunity to do that later. Your objection's noted. It's overruled. The state may continue.
Overruled.
I apologize.
We showed you at the very beginning, remember our first witness was Sergeant Warner, the man who was the incident commander for the parade. We put up another map. I think it states Exhibit 1. You can have that if you want it. Shows all the positions of all the police officers and the reserve officers, the barricades, the squad cars. How do I know it was intentional? Because even Darrell Brooks told Detective Carpenter, I could tell something was going on downtown. No reasonable person would drive upon this area, see the squads with their red and blues on, see the officers in the street with their bright yellow vests, see all the people milling around, see the floats lining up and the participants getting ready, and not know to drive safely, slowly, and obey officers. The barricades help us prove it was intentional. The police presence help us prove it's intentional.
I agree.
Parade participants help us prove it's intentional, and the parade spectators help us prove
hi,
it's
Linda.
intentional.
Excuse me, Attorney Hopper, your objection, sir?
Oh, yes.
Speculation as to what the alleged defendant said he saw. It
Sir,
was never.
Your objection's noted. It's overruled. This is closing arguments, not the evidentiary phase. Go ahead,
So
Attorney Hopper.
how can speculation be made to what was saw? If
Your
that was never
objection's
testified
noted.
to?
It's overruled. Continue, Attorney Hopper.
Honking the horn. Quite interesting that Mr. Brooks asked so many witnesses if they heard the horn honking. Some of them said they did at the beginning of the parade. Yeah, I heard a horn honk. Most of them said they didn't. The horn honking cuts both ways, folks. If he's honking his horn, that means he can see something's in front of him. That means he knows there's an object in the road. You can rely on your common experience in your affairs of everyday life. If you see something in the road and you want to alert the other person to your presence, you will honk. But you do not have the green light to then just keep going if they don't move. He knew they were there. Intent. I've skipped one. I'm sorry. Going back to my street, number 15, I failed to include the Catholic community. That's just one of the photographs showing the people that will match up to Exhibit 15 from the Catholic community of Waukesha. There's a lot of photographs identifying the people that were marching with that group.
Sorry, it was a preemptive
Parade
objection.
started. This is the starting point.
I thought that he was going to object.
Near the beginning, right? This is the area We showed some videos of the groups passing by in this area. We heard testimony from 4 different police officers standing in 4 different spots near here, telling of their 4 different efforts to stop him. Intentional. Sergeant Wander's back here testified that this red SUV blew by me. I waved both arms over my head. I'm in a police uniform. I have an unmarked squad, but I have my red and blues on.
I can feel
And
it.
he blew past me. He gets down here to the corner where Detective Casey is standing. Detective Casey runs out into the street, gets close enough to put his hand on the hood of the car. He keeps going.
Does
He
he?
comes down, turns onto Main Street, gets in this area of East Avenue to the south and Buckley Street to the north. This is where he encounters Officer Schneider and Officer Buttrin. They each make a separate effort to stop him, and he keeps going. 4 police officers. It's intentional. He had plenty of opportunity to just stop.
Is he gonna
Anywhere
make? Does he
along
get
the
to
way.
make his today?
One of the officers testified to it. I think it was Officer Schneider. If this was an accident and he mistakenly wandered onto the parade route after passing all this, and he mistakenly wandered onto the parade route at any point, all he had to do was stop. They could have paused the parade.
up, Plant Love?
They could have moved the barricades and escorted him out. He didn't.
He gone.
It was intentional.
It was intentional for sure.
He went on for 4 blocks. 4 blocks. It was intentional.
Right.
He reached speeds of approximately 30 miles an hour.
Jeez, dude.
That's intentional. He plowed through 68 different people. 68. How can you hit 1 and keep going? How can you hit 2 and keep going? How can you hit 3 and keep going? Didn't phase him a bit.
I love this lady.
He kept going until he got to the end.
She's
and there was
good.
no more bodies to hit. It's
Your objection,
intentional.
sir?
Mischaracterization of the evidence.
Noted, overruled.
Overruled.
His conduct when he left the parade route. We'll get into this. His flight, his hiding, his panic, his desperation to run. Get the hell out of town as fast as he could before the cops came.
Yeah, I really like her. She's
That
good
shows
stuff.
his intent. His interview with Detective Carpenter, we spent several hours playing you snippets of that interview. How telling was that? Never once did he say any of these things. Never once did he say, like he told you in his opening statement, it wasn't an accident. It wasn't intentional. Never said that to Detective Carpenter. No, he came up with some convoluted story about, I got a ride out here from a buddy in a tan Kia, and then I left to go meet Erica, and we got into a fight, and then I went back, and the other guy got into a fight, and he was leaving, so I took off on foot. Absolutely nonsensical story. Does not match up with the known evidence in this case.
Overruled.
Oh, he objected.
He never
I didn't
stopped.
even state the objection.
This is closing argument. She may continue.
I'm going to play this slide, which is a snippet from State's Exhibit number 53. Go ahead and play with sound, please. That was just a snippet that I selected because I thought it really captured the environment that so many witnesses tried to explain to you, right? It's a Christmas parade. People
Bye,
are there
Grammy.
with their families, their little kids, their grandkids, their neighbors, their friends, strangers, standing next to strangers. That's what's going on Main Street. While that's going on Main Street, this is going on. Remember this? This is the gas station on the corner of Barstow and North Street. While the units are marching down Main Street, entertaining the crowd, Darrell Brooks is driving recklessly. He's enraged, and he's arguing with Erica Patterson. Why is this important? This is important because before he even gets to the parade route, this is how he's driving. He drives the wrong way down North Street and then acts like it's everybody else's fault in the world.
Your objection is noted. It's overruled. You may continue, Attorney Opera.
When he finally pulls into the gas station, he rolls down his window and yells at the driver who's properly stopped at the stoplight that it's somehow that guy's fault that Darrell Brooks is trying to drive the wrong way down North Street. And from there, the rage continues. We get to this point, State's Exhibit number 3. Please play. The video is playing. You can see the pushing match between Darrell Brooks, Corey Runkle, Erica Patterson, and Nick Kirby. Watch this. He turns to get in the car, flips up his hood, and goes and gets in the passenger seat. I'm sorry, driver's seat.
How long are we going to mischaracterize testimony?
Sir's argument, I've heard nothing improper. Your objection's noted. It's overruled. You may continue, Attorney Opera.
I don't think so, but I don't know.
To know they can nullify.
That's it. He drives off onto the parade route. From this moment, right here on Exhibit 15, you're watching it. He's enraged. He's angry. Flips up that hood, and he zooms past Sergeant Warner, past Officer Casey, onto the parade route. Now, there's no doubt, for the first 2 blocks, he does not strike anyone. And as we've discussed, some even said he was driving at a reasonable speed initially. By the time he gets past Officer Buttrin and Officer Schneider in this area here of East Avenue, past East Avenue, and clearly once he gets past Barstow, that's where it starts, right? That's where it starts. Nicole White, our first victim, walking with Remax and the hot air balloon. Knocks her over, keeps going, runs up and over the backs of Waukesha South Band, hits the green children spectating on the sidewalk, keeps going, runs over Kelly Grabo and her daughter Adelia walking with Burris Logistics, keeps going, plows through the entire Extreme Dance team just before the 5 points, keeps going, hits Deborah Ramirez and her son Isaac spectating on the south side of the street, keeps going, clears the 5 points area, hits Jane Kulik square on, causing her to go up on the hood of the car, and then fall off and drives over her body. He doesn't stop. He keeps going. runs through the kids over by the steaming cup. We heard the parents testify about little Brinley and Kelsey and Owen that were standing there outside the steaming cup. They were struck by the red SUV driven by Darrell Brooks. Keeps going. Plows through the grannies in that zigzag fashion, striking most of them, injuring them, killing them. Keeps going. Gets down here to the end and goes through the Catholic community. The witness, remember Holly Berg, she testified about that mobile gas station incident. She said she was standing down here in this area. She said, I saw 15 to 20 people fly in the air. They looked like bowling pins. And when she saw the video, she's absolutely right. It's a terrible description when you think these are human beings, but that's exactly what it looked like. When does the intent exist? Doesn't have to be even for a second. I'm not telling you who set out that morning to cause this carnage. But when he became enraged back here, he didn't give a damn who or what was in his way. He intentionally went on. I'll show you. Motive. I don't know why he did this. Folks, I don't know why. Other than the rage. He's right. You cannot read minds. Neither can I. But the law doesn't require you to. The law gives you a way to reach a conclusion as to what is somebody thinking. And it's right here. Decide it based on his acts, words, and statements, and from all of the facts and circumstances. I've already been through many of them. I want to show you what I mean. Look at this. Was there room for him to get out? This is way back at the beginning. This is Officer Buttrin's squad video. Way back at the beginning. That's Buckley Street here that you're looking at. Look at those barricades. Look at the sparse crowd. And there's Officer Schneider in her yellow fluorescent vest on the left side of the picture, about to run into the street and stop him. Intent. I'm going to play this video for you because, folks, for me, this is where it becomes crystal clear. You watch this video, the first thing you're going to see if you direct your attention to the left side of the screen is you're going to see him hit Nicole White. Knock her to the ground and keep going. Now, if that was the end of the story, you may sit here and say, Madam DA, I don't know how you conclude intent from that. Maybe it was an accident. Maybe he didn't mean to do it. But watch what happens in this video after he knocks Nicole White down and tell me this does not prove intent. Please play. Keep watching the left side of your screen.
Oh my God. Oh my fucking God.
That's intent, folks. No reasonable person is going to come across a group of teenagers playing band instruments, drive over them, and keep going.
Just the audio's bad.
That's a still shot of the same thing. That's intent.
I'm sorry to interrupt your objection, sir.
How can you tell the jury what they supposed to think?
It's proper argument. Your objection's noted. It's overruled. You may
It's,
continue.
I would argue that it's,
Attorney Hopper.
I would say that it's improper, and I move
Mr.
for a
Brooks said,
mistrial.
made my ruling. I'm going to mute you if you don't follow the rules.
Overruled.
Exhibit
For a
1,
mistrial.
Exhibit 152. Clearly intentional conduct.
52.
Clearly intentional conduct. States Exhibit 93.
Jesus.
We ask the court to take time to have you go look at this car in person because it's remarkably amazing that this damage was caused by human beings.
Exactly. Looks like he ran into
That's intent.
a wall.
This is an excerpt from States Exhibit 154. Maybe a little hard to see. A lot of that laying in the front part of this photo are shoes. Remember what Dr. Bidritsky said about the shoes and the feet, the scuff marks on the toes and the ankles? Look at all the shoes laying in the street. This is the area at the end when he ran through the Catholic community. All the shoes laying there because of the velocity. Remember, the medical examiner talked about the velocity. It's not just the speed, it's the velocity. The power that these people were knocked right out of their shoes. That's intent. The flight, the hiding, changing his appearance. He had to go through some effort, right? Crawled up in this playhouse, ditched his sweatshirt and his sandal. The other sandal seems pretty reasonable. He dropped it when he was jumping over a fence. Changed his appearance. Please play.
Excuse me.
Intent. What's he running from? What's he running from if he's just a lost guy with no ride back to Milwaukee? What's he running from as there's cops, sirens wailing in the background? Whoops, that was me. So, States Exhibit number 130. Put that up here quickly. Take this. Thank you. I'm not going to go through this whole thing, folks. Suffice it to say, after Officer Skolton tried to stop the threat at that intersection at the top, Wisconsin Avenue, and he blew through the barricades there, and drove south on West Avenue over to Prospect Court, cutting through the yards and ditching the vehicle on Maple. Heard all the testimony about the commotion on Maple. The eyewitness testimony from Officer Sailors, off-duty police officer who saw this, saw the defendant, Darrell Brooks. He identified him for you in this court.
Eyewitness.
Get out and run from this car. And how we tracked him through the neighborhood. And again, the desperation, whether he had to ask or use veiled threats like, I won't hurt you, but I need your phone. He was absolutely desperate to get out of there until he took refuge in the home of Daniel Ryder. Now remember the interesting thing, folks. None of these witnesses in this area knew anything about what happened at the parade. None of them. None of them were there. None of them were there. So some of them tried to help, some of them didn't. Daniel Ryder did, and it's actually probably a really good thing that he took him in because it stalled, right? It stalled them from keep running, kept them in one place until the cops could close in and get there. Now, Mr. Brooks repeatedly asked witnesses who had just watched their loved ones get struck by this SUV if they happen to catch a license plate.
Oh my God.
States Exhibit 150. There's the front license plate. Definitely a little blurry, but definitely you can make it out. States Exhibit 151. There's the rear plate. States Exhibit 175. There's Darrell Brooks in his music video with the same car and the same license plate. There's the key to the Ford that was found in Darrell Brooks' pocket. There's no doubt Darrell Brooks is the person responsible for this. Because this man in this picture is the same as this man in this picture wearing this sweatshirt. And again, it's a little hard to see, but you can ask for these exhibits in the jury room if you want. The photograph, you can see this design on the front of the sweatshirt if you look close enough. This is a sweatshirt from the playset that has Darrell Brooks' DNA on it, according to the crime lab. That's him right there. That's Darrell Brooks driving off into the parade. That's Darrell Brooks driving in the parade. That's Darrell Brooks driving in the parade. That is also Darrell Brooks driving in the parade.
God dang, man.
And so is that. And he kept asking people about the tints on the window. Well, guess what, folks? You don't need to see the tints on the window when the windows are rolled down. And there's clearly one person in that vehicle in every one of these photos. And it's that man. And it's that man. And it's that man. Darrell Edward Brooks Jr., date of birth 2/21/1982.
We got an objection
on
from him?
his identification card issued by the state of Wisconsin.
Here we go.
In all capital letters, Darrell Edward Brooks Jr. This was in his pocket when they arrested him. So this entire shenanigans that he's presented to you through his questioning of witnesses about I'm not Darrell Brooks and that's my name and I don't know who that is and I don't consent to being called that name. It's just nothing but a distraction. It's Darrell Brooks.
She knows this is pissing him off,
It's
too.
the man who drove through the Waukesha Christmas parade and killed people, injured people, endangered the safety of people.
I'm sorry. Your objection, sir?
Your Honor, with all due respect, I would appreciate the quote unquote language what does she mean by shenanigans and this and that and the third.
Sir, your objection's noted. It's overruled.
Overruled!
Well, can she tone that back? Because if that was me, if I would have said
Mr.
something
Brooks,
like
your
that, it would have been a
objection
problem.
is noted. It's overruled. These are closing arguments. There's nothing
I just-
improper. It's
I
noted.
just
It's
wanted to-
overruled. She may
I
continue.
just wanted to be fair.
You'll have
Your
an
Honor, that's it.
opportunity to respond, sir. Please let her finish.
So I can rebuttal.
Go ahead, Attorney Opper.
Thank you.
Overruled!
I'm going to conclude my comments with this, folks.
Uh-oh. She's closing?
I'm going to show you the video, a stitched together video of all the carnage caused by Darrell Brooks, and I apologize.
Stitched together.
This is important that you know what he did. It's important that you think about the women like Nicole White and Kelly Grabo and her daughter and Jane Kulik, who were just there with friends and co-workers supporting a local business. The teenagers marching in the band, representing, wearing their school colors. It's important. The boys and girls with the Blazers baseball team and their coaches doing nothing more than handing out baseball cards.
Sad.
The young girls in the extreme dance team. Can you imagine how many hours they spent practicing that routine? He drove right through them without a care in the world. The grannies dancing their way down the street, perfect step. every one of them. Catholic community there, as Father Matt said, spreading the light of Christ in the weeks before Christmas. He snuffed it out. It's time for Darrell Brooks to stop running. It's time for him to stop lying. It's time for him to be held accountable for his actions. Darrell Brooks cowardly rammed his way through this parade, violently killing and injuring so many people. I'm going to stop talking and play this video, but please, I ask you to add up the evidence. Use the map. 15. You can check off the names. We've covered them all. Walk down that street like we did with you. Return guilty verdicts on all counts. Please. Please.
Screen back up.
No, I need one more. Yes, please.
I agree with that.
Go ahead.
Wow. I mean, it's just... I've seen some of the videos on when this first happened, and it was all over the place. It's just... He doesn't even care. He doesn't care. You're a dick, dude. Seriously. Such a dickhole.
Thank you. Before we continue with Mr. Brooks's closing arguments. I am going to take a short break. All rise for the jury, please.
Yeah, incredible. That was powerful, man. She
Muted.
No.
The jury should know that they can nullify.
You are muted now.
What an idiot.
Thank you. We'll be in recess for about 10 minutes.
10 minutes. All right, I'm going to go pee and get some water. So we'll be back here too. I'm not cutting the stream. I'm going to keep the same stream, so stay in chat if you want. Do whatever you want. We'll be back. I fully expect Mr. Brooks to not, and I'm gonna stop calling him Mr. Brooks. I'm gonna start calling him what's a good name for him? Shithead. Oh, sorry, no cussing. I doubt he'll probably end up having to forfeit his closing argument because he's going to just say stupid stuff. Thank you for being here with us. Little special coverage of one of the most ridiculous trials I've ever seen. I know. He's ridiculous.
Here wasn't selling.
Sir, you're out of...
Offered to, how I know? Someone here, and I'm not gonna say who, offered to buy it. Only Charlie here wasn't selling.
Sir, you're out of order.
Out of order? I show you out of order. You don't know what out of order is, Mr. Trask. I'd show you, but I'm too old. I'm too tired. I'm too fucking behind.
Stop cussing, Pacino. Out of order, I'll show you out of order. Out of order, I'll show you out of order. You haven't seen out of order. I'd show you. 20 years ago, I'd have taken a flamethrower to this place. Out of order, I'll show you out of order. Out of order? You out of order. You out of order. I don't know. I like that. You out of order. I'll show you out of order. Where's my stupid faith? Out of order. I'll show you out of order. You haven't seen out of order. Yeah, he he didn't care about driving over those people. He's not gonna make. Trust me, he's not gonna make it very long, and he's gonna end up forfeiting his. He's gonna end up forfeiting his right because he's out of order. He'll be out of order. Trust me, he'll be out of order. Hopefully not. Don't get too excited, folks. I'm telling you. I just don't. I thought that he was going to make it 10 minutes when they brought the jury in. 10 minutes, maybe less. He didn't even make it till the jury came in. He wants to tell them that he's got a shock collar on his balls, or that he's been beaten and bruised by some boxes. He wants the jury to know that he's been mistreated. Blah blah blah. Out of order. I'll show you out of order. Your Honor, members of the jury, they put a shock collar on my balls. And I'm out of order. If I'm not out of order, you are. Shenanigans. I'll show you shenanigans. Where else do you get this kind of crap at? Yes, he's got 1 hour. I'm going to be Al Pacino for the rest of this stream. Oh. I love a good Al Pacino. Oh, I'll use shenanigans, trust me.
Oh, I'd take a flamethrower to this place!
Oh!
Out of order. Who the hell do you think you're talking to? I've been around, you know.
I've been around, you know. I can actually... I can do the voice pretty well, actually.
There was a time I could see, and I have seen, boys like these, younger than these, their arms torn out, their legs ripped off. But there is nothing like the sight of an amputated spirit. There is no prosthetic for that.
There's no prosthetic for that. There is no prosthetic for that. And they tried to buy him, but he ain't selling. Out of order. I'll show you out of order. I'll show you out of order.
You think you're merely sending this splendid foot soldier back home to Argonne with his tail between his legs, but I say you are executing his soul. And why? Because he's not a bad man. Bad men. You hurt this boy, you're gonna be bad bums. The lot of you.
The lot of you. The lot of you. Come on, when's Dummy coming back? Amputated spirit. I can't do a Don Wells on a Tuesday or a Monday or a Tuesday. Mostly on Tuesday. Mostly on a Tuesday, I can't. Yeah, the lot of ya. I love when he says that. The lot of ya.
And Harry, Jimmy, Trent, wherever you are out there, fuck you too.
Oh, come on. I'm really sorry. I really... That was for you, Mr. Brooks.
Don't say any F's and stuff.
Stand.
man down, Mr. Slade.
I'm not finished.
He's not finished.
As I came in here, I heard those words, cradle of leadership. Well, when the bow breaks, the cradle will fall.
Down.
It has fallen here.
Down will come baby, cradle and all. Ho, ho, ho. Merry Christmas.
It has fallen. Makers of men, creators of leaders, be careful what kind of leaders you're producing here. I don't know if Charlie's silence here today is right or wrong. I'm not a judge or jury, but I can tell you this. He won't sell anybody out to buy his future.
That's right.
And that, my friends, is called integrity.
Uh-oh, I think we're
That's
coming
called
back.
courage. Now that's the stuff leaders should be made of.
Love it! Love it! Are we, what do we got going on here? Kelly, yes, I did look your Vargas guy up. The one that you said that looks like me? Because I kind of look like Don DeLuise, right? Yes, it is longer than 10 minutes. They're out of order. The lot of you. Here we go. I got really excited. It's too much. Calm down. He's in the courtroom! Ah! Out of order. I'll show you out of order. In his younger years, I look like Don DeLuise. I know. I'm pumped for this. I'm pumped. I've been waiting.
Record should reflect that Mr. Brooks is now present in the main courtroom.
Oh, we see him.
Prior to reopening following the break, I did invite him back into the courtroom.
How nice of you.
And he is here. I trust you are ready with your closing argument, sir.
I'm ready to address subject matter jurisdiction as well, too.
That request is denied.
Just for the record, I was addressing it for both courtrooms here in courtroom number, I think it's 20.
Mr. Brooks, I'm going to bring the jury out. Are you prepared to present your closing argument?
I would like for you to prove subject matter jurisdiction on the record, Your Honor.
I'm not addressing that any further than I've addressed already, sir. There's a written decision. I remind you of that.
In that written decision, did I receive, well, actually I didn't receive anything. Was there copies made?
Mr. Brooks, I'm going to ask you one more time. Are you prepared with your closing argument? I'm going to have the jury brought out. There is no other legal arguments I need to address from you at this time.
I'm informed of what you're saying. I was merely asking, was there copies made of your, you said written decision?
Sir, my written decision has been filed into the record. That is done electronically. You were provided with a written copy previously.
He's out of order.
Are you asking for another copy of that, sir?
Yeah, because I don't have it.
As a courtesy, I'll have my clerk print off a copy and provide that to you.
How nice
Is it
of you.
proven subject matter jurisdiction?
Your objection to the lack of jurisdiction has been noted repeatedly on the record. It is a meritless argument. I've indicated that in my written decision as to why there is subject matter jurisdiction, and I will continue forward with the final stages of this trial,
He doesn't want it to
which
end.
I hope include your closing argument and then the final instructions to the jury.
I would hope it proves subject matter jurisdiction on the record too.
All right, I will instruct the jury to come out. For the record, the written decision is once again being provided to the
I accept
defendant.
for value and return for value this document, as it is not based in lawful law,
Stand up, dummy.
and it does not prove subject matter jurisdiction whatsoever. Refers to some complaint that was filed in the name of a trust.
It's going to
Not my
ruin
name.
it. That's all right.
Were you aware of that, Your Honor?
Mr. Brooks, the jury has been asked to be brought out. I mean, I've requested that they be brought out. They're on their way.
Were you
Please
aware of
be
that?
prepared with your closing argument.
Were you aware of that, Your Honor? Or is that a tacit agreement that you don't have to answer any questions as a public servant?
First Amendment
All right.
auditor.
So that is a tacit agreement.
A tacit agreement. Yeah, dude, it's a tacit agreement.
Record to reflect the jury is coming out.
It's a tacit agreement that they're coming out. So stupid. What he's gonna do is he's gonna forfeit this because he's gonna be a jerk off, and then on appeal he'll say he didn't get a closing argument. That's what he'll say.
Thank you, everyone. Please be seated. Go ahead, sir. You may begin your closing argument.
Oh no.
I'm not ready to begin closing arguments.
So this is your opportunity to provide your closing argument to the jury. Please start. I've started the timer of 1 hour.
I'm informed of that, Your Honor, but I'm not ready to proceed as I don't understand the reason why the questions asked before the jury was present were not answered. There are issues that needed to be addressed outside of the jury, as you always say, which I don't understand why. The jury deserves to
Mr.
need
Brooks,
to know.
this is your opportunity to present your closing argument to the jury. Please do so.
I'm informed of that, but the jury needs to understand the truth, their rights, and their duties, as they have not been informed of their truth, their rights, and their duties.
Mr. Brooks, the court has begun the instruction process. I read 73 pages this morning, and into the early afternoon, I have another 30-plus pages to read.
Did you inform
They will
the
be
jury-
informed of the law.
Did you inform them that they
Mr.
can nullify
Brooks?
the law?
Mr. Brooks, you do not have that right to request that. And
Were
I'm
they
advising
informed?
you, one more time, this is your opportunity to provide your closing argument. Please begin.
I intend to when ready. I just want to know if the jury was informed that they can nullify the law.
Mr.
That they
Brooks,
are-
you
that
have
they
no
have
right
the
to
power.
make that argument to the jury.
It's true. They have the power.
All right, I'm going to excuse the jury.
Uh-oh.
They should know that they have the power.
He
Rise
gone.
for the jury.
Out of order. You out of order. Dumbass. He's so stupid. Messed up. You messed up big time, dude. Those poor jurors. It's nothing at all.
Thank you. Please be seated. Mr. Brooks, you do not have a right to request jury nullification directly from this jury. I direct your attention to the Bjerkas case, Bjerkass, that's State versus 163 Wisconsin 2nd 549. While you are not incorrect that the jury has the power to nullify, they don't have the right to do so, and no party has the right to instruct or to request an instruction or to argue jury nullification. You may talk in terms of fairness in general terms, but you may not go further. You may not argue that the jury should discard the instructions in the law and find you not guilty for that reason. You may not use the phrase jury nullification. You've done that now at least 3 times in earshot of the jury. Twice while you were in the other courtroom, I was able to mute half of what you said the second time, and then of course you raised that once again while in front of the jury just now. You also indicated you weren't ready to give your closing argument. Sir, the time has come for you to give your closing argument. If you choose not to do so at this time, then you will forfeit your right to present a closing argument by your conduct.
I haven't made any such choice, so you can't coerce me into a constitutional right waiver when I have not waived the constitutional right, and I will not allow you as a public servant to do that. I have not made a choice.
Sir, the time has come for you to present your closing argument.
Are you making a judicial determination
Bipolar
that you're
bear.
denying me a constitutional right in
I have
open
not
court
made such
on
a
record
determination as of yet, but you can forfeit your constitutional rights
under
by
what
conduct.
lawful law?
Illinois versus Allen, State versus Anthony.
Illinois versus Allen does not reference anything pertaining to rights when talking about
In
closing
State versus
statements.
Anthony,
Illinois
the Supreme
versus
Court
Allen.
of Wisconsin referenced both that decision when it essentially extended the reasoning or adopted the reasoning of Illinois versus Allen to then find that a defendant could forfeit an important constitutional right by conduct. In State versus Anthony, it was not the right to be present in the courtroom, it was the right to testify.
Okay, so none
And
of those
the
that you just
reasoning-
named have anything to do with the closing arguments, Your Honor. You've used Illinois versus Allen repeatedly to when it comes to me being removed from the courtroom. Not one time did it bring up anything dealing with a closing statement or a closing argument. So how's that same statute being used for something that it doesn't even refer to or pertain to?
Mr. Brooks, the Allen decision, Illinois versus Allen, and the Anthony decision, which is State versus Anthony, are 2 examples of cases where a defendant lost a very important constitutional right because that right was forfeited by the conduct of that particular defendant.
And that was to be present in trial, correct?
The right to present a closing argument is no different. Because it is not evidence, it could be said that it doesn't even rank as high as the right to testify, which is guaranteed by the constitutions.
Which I was denied the
I'm
right
not prepared to
be
make
able
that
to testify
ruling
to.
here yet today. Sir, the time has now come for you to present a closing argument. There will be no further delays.
It's
I
not a
will not
delay.
be taking any further adjournments for you to prepare. You were advised yesterday that this court would proceed today with instructing the jury and with the parties making their closing arguments.
And you made that while
It is
violating
up-
my constitutional
Sir,
right.
please don't interrupt me because
Well,
you've now
you did.
interrupted me a couple of times.
No, once. So let's
Twice.
make that correct. Once.
That's
3
the third
times
time.
now.
Okay, now you can say
So, Mr. Brooks, I'm advising you yet again. The
I
time
don't
has now
consent to
come.
being called
That's
that
another
name, Your Honor.
interruption. The time has now come for you to present your closing argument to this jury. You
And-
were brought back over to this courtroom for that purpose.
I'm going to let them
That's
know.
another interruption.
No, I'm going to let them know that they have rights and they should be informed of the truth. It's not me
Are
trying
you
to
telling
give.
me, sir, that
it's
you
not
are going
trying
to
give.
let me ask you a
No,
question.
hello. I'm not trying to give any
Sir, you're
jury
interrupting
instruction.
me and you haven't let me finish. So are you telling me that you are going to disregard my very clear directive to you to not bring up the topic of jury nullification?
That's not what I said.
That's why I'm asking you.
I don't understand that question because that's not what I said.
Sir, you may not argue jury nullification
I'm
to
going
this
to
jury.
inform them of the truth.
So you're going to inform them that they have the power of jury nullification.
They do have the. You just said on the record that they have the power for.
Sir, I direct your attention.
You just said that.
once
Did
again.
you not just say that, Your Honor?
Sir,
You
the
said
jury,
I couldn't instruct them.
The jury
on
has
that.
the power, but not the right to nullify.
Right.
A
You said the
party-
power. You said the
Listen
power.
to me, sir. You're interrupting me once again.
So I'm going to inform them that they have the power.
Are you telling me, sir,
I'm
that
not
you
telling
are
you no
going
such
to
thing.
disregard
I just told you what you just said.
my directive to you to not raise the issue of jury nullification during your closing argument?
That's not what I said. You just read and said that they have the power to. That's what you just said, Your Honor.
Sir, State versus Bjerkas says and stands for the proposition that although the jury has the power of jury nullification,
they have the power.
No party has the right to argue for jury nullification.
I'm not arguing for it, Your Honor. I
In
just
that
want them to be
case,
informed. I just want them really to be informed.
You can
That's
call
it.
it informing, making them aware.
Yeah, they should be aware
You
of
are
the
not
rights.
allowed to make them aware of their power to nullify.
That's
That is
the
an
rules.
improper argument.
Your Honor, how can I not inform them that they have a power? How
Because
can I
that
not
is not a
inform them
right
of a
that
power
you
that they
have,
have? I'm not giving a new jury instruction. That's not what I'm arguing.
There is no jury instruction for jury nullification,
Yeah,
sir, because it's not allowed.
I'm not attempting to give them a new jury instruction. I'm merely attempting to inform them of the power that they have.
Mr.
That's not
Brooks,
against the law.
I'm advising you one more time. You may not raise the issue of jury nullification
I'm going
before
to
this
inform
jury.
them of the power that they have. I'm not
You are
giving them.
telling me
I'm
that
not
you
giving
are
them a jury
insisting
instruction.
on telling them about jury nullification. That's
That's-
what I hear you saying.
That's not what I said, though. Don't mischaracterize what I'm saying. You just read and said that they have the power. They have the power to do that. So how is
It's an
informing them?
inherent power that they have. They are not to be instructed on it. That is very clear in the law. In
Your
addition to, no, let me finish. In addition to the case that I just cited, I'd cite to you from the jury instructions the law note on jury nullification.
Okay, let me explain a little bit about jury nullification and why he's so insistent on this. Now,
But the bottom line is, it is improper for a court to allow a defendant or a defendant
Basically-
to make an argument or make the jury aware that they have the power to nullify a verdict.
right. Well, it's not even that. It's that if they disagree fundamentally with the law that the person's being charged with, if the jurors can't agree,
Issue.
Mr.
It
Brooks,
never was brought up.
If you
But
think
then when I
wasn't-
raised the issue,
if
Your
you
Honor, let
think
me
that
finish.
I'm not prepared to deal with an argument on jury
I
nullification,
didn't say.
then you
That's not what I said. That's
You are
not what I
missing the
said. In
mark.
all fairness, that's not what I said.
The record should accurately reflect that you were kept in that holding cell.
Why was I kept
so
in there?
that my clerk could finish
Adding a jury instruction that
it's
was not there.
it's a Hail Mary for him. He wants jury nullification. He wants them to be thinking about that when this goes to deliberation. But the thing is, there's no law that anybody's arguing with. You can't run over people. And so jury nullification is extremely rare. It's just the dumbest thing.
This court. You
Here we
you
go
can
with this.
roll your eyes
Here
at me
because
all
it's,
you want.
It's ridiculous, Your Honor. You just stated that they have the power to nullify
Would you
any
like,
law.
if you would like,
but then
I
I
will
said,
read this to you, sir, the part of the case that's important, but you're not letting me get a word in edgewise. I'm trying my best not to remove you to the other courtroom, but that is oftentimes what I need to do in order for this court to make a full record without you interrupting me. But you need to be fully aware that you may not raise the issue of jury nullification in front of this jury. It is not an allowable argument or an advisement or making them aware. However you want to describe that, sir, whatever verbiage you want to put in front of it, you may not do so. And this court has the power and the authority to limit what you say to this jury, even in a closing argument. And if you're telling me through your conduct, through your words, that you are going
And if he does, that should be the end of his closing argument, and then let the jury decide. He's basically forfeiting his right by doing this because
Doesn't refer to that.
State versus Anthony
it
may
doesn't.
not have dealt with
It hasn't dealt with
the
closing
right
arguments.
to a closing argument, sir, but the reasoning
You just said it right there.
nonetheless is
No.
fully applicable.
No,
because the more
you can't
general
change the law, Your
principle-
Honor. You can't change the law. That's
I'm
practicing
not
law
changing
from the
the law,
bench.
sir, but the general principle.
I know you used to be in legislation, but you can't practice law from the bench.
Sir, I'm
You
not
can't do
practicing
that.
law from the bench.
You are if you're changing. Your Honor,
I'm not
you're
making-
attempting to make a separate case pertain to something here that doesn't even pertain to it. It has nothing to do with a closing argument. Nothing that you just
So,
named. Not
Mr.
Illinois
Brooks,
versus
I
Allen.
would like to make a record. Would you please show the courtesy and respect for
I
me
will,
to
Your
do
Honor.
that?
I will.
All right. So, looking at the Anthony case,
you're not going to change your
All right.
mind, dummy.
and that case starting at head note 7, paragraph 54 says the following, and you need to let me get all the way through it. We have recognized two distinct ways in which a defendant
Please hit that
may
like
give
button
up
while
his
you're here,
rights.
if you
Waiver
haven't done
and
so yet.
forfeiture. State versus Pino is the first citation that they reference. Waiver is the intentional relinquishment or abandonment of a known right. Multiple citations there, I won't repeat them all. Waiver typically applies to those rights so important to the administration of a fair trial that mere inaction on the part of a litigant is not sufficient to demonstrate that a party intended to forego that right. State versus Soto. Forfeiture, on the other hand, often involves the failure to make the timely assertion of a right. That's a cite to the Dina case and Olano. Rights that are subject to forfeiture are typically those whose relinquishment will not necessarily deprive a party of a fair trial and whose protection is best left to the immediacy of the trial, such as when a party fails to raise an evidentiary objection. However, there is a second aspect of forfeiture, doing something incompatible with the assertion of a right. State versus Vaughn, 2012 Wisconsin Appellate 129, citing Illinois versus Allen, 397 U.S.
I think, but hasn't she already like
337.
read him this stuff?
They went on, the court, that is the Wisconsin Supreme Court in Anthony. As previously noted, we have held
gonna
that
take
the
a bite,
right
my
to
baby.
testify is subject to waiver, not forfeiture,
hungry,
insofar
Gordon.
as a defendant's inaction in asserting the right is concerned. We now conclude that the right to testify may, in appropriate cases, be subject to forfeiture where conduct incompatible with the assertion of the right is at issue. They go on to discuss Allen, which was not a right to testify, but was a right to be
He's not.
present.
He's not listening. Doesn't matter.
And I am utilizing the guidance from Illinois versus Allen and State versus Anthony. It directly guides this court that a defendant may forfeit a right by conduct by doing something incompatible with the assertion of a right. In this particular case, you are very clearly telling me you are going to disregard what I told you about notifying the jury about nullification.
Yes.
You have absolutely no right to raise that in front of the jury. It is improper. And unless you're willing to tell me you will honor this ruling of mine, then you will forfeit your right to present a closing argument. That is my ruling.
I object to that ruling, Your Honor. Object to that ruling.
You
Are you
can't.
willing to make a closing argument, sir, that does not reference jury nullification?
I'm going to inform the jury of their power. Again, I never stated that I was making a new jury instruction. I never stated anything like that. And every case law that you just stated made no reference to closing arguments. It was all pertaining to being present for the proceedings of trial and for testifying.
Sir,
Not
what I'm
one time
telling
did you, hold on, I let, Your Honor, with all due respect, I let you make your record. I didn't interrupt you.
Go ahead.
Not one case law that you just cited made any reference whatsoever to a closing argument. Not one. So how is me merely informing the jury of the power and the rights that they have, how is that a forfeiture of being able to give a closing argument?
Well, in addition to the cases I just cited, sir, I'd also point you to State versus Bajirkis, 163 Wisconsin 2nd at 549. That's a Court of Appeals case from 1991. That is the first published appellate decision in Wisconsin to consider directly several issues relating to the jury nullification issue. In that particular case, the court very clearly said that the defense counsel in that case was allowed to talk in terms of fairness in general terms, but not to go further, and could not argue that the jury, quote, should disregard the instructions and the law and find her not guilty because it seems fair. That's a description of jury nullification. To use the words jury nullification would run afoul even more. And so I am telling you that given my inherent authority in controlling the mode and order of this court to ensure courtesy, decorum, and civility, and to ensure that this jury is presented with arguments that are proper under the law, I am hereby telling you I am in creating a rule for your closing argument that you may not raise the issue of jury nullification in any way.
Your Honor, hold up. Hold up now.
Uh-oh.
I'm the only one that has to be made rules for closing arguments, but not the prosecution? How is that fair?
Because they follow the rules.
Mr. Brooks, I'm squarely faced with your defiance regarding the issue of jury nullification.
It's
that
not
is
defiance.
Requiring
It's
me
not defiance.
to address this issue and to tell you very
Your Honor,
expressly
I
that that is the
vehemently-
rule
I
for
vehemently
your
object to
closing
that.
argument.
Vehemently object to
Vehemently.
Your objection is noted for the record. But
that. May
my
I ask
rule
for a legal
nonetheless
reconsideration of your
stands.
ruling?
No.
That request is denied.
May I respectfully ask for, matter of fact, I reject that ruling and take exception to that ruling. For the record, may I request a legal or factual basis for your ruling? Not one pertaining to being present in the courtroom or testifying. One that specifically talks about a closing argument.
All of those requests are noted. I will not reconsider. I've put my findings and my reasoning on the record, and I stand by that record.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law?
Denied.
Bye, Tracy.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
I'm not the forum for which an appeal would be sought, sir. I cannot answer that.
You referred to it before.
You would need
So
to
now I'm
direct your
confused.
appeal to
I'm confused, Your Honor,
a court of
because-
appeals, not this court.
No, this is. I'm supposed to be in this admiralty court because you haven't. If we're under Article 3, then we should be in common law court. That hasn't even been addressed. If we're in a common law court or an admiralty court.
Unreal.
That's a baseless argument, sir. Don't even need
And
to
what
address
law
it.
and fact? Based on what law and fact?
It's meritless.
Based on what law and fact?
What law and
Sir,
fact?
I intend to bring this jury out and give you
I'm
an
informed.
opportunity
I'm informed of that.
to present a closing argument.
Yeah,
If
but
you
you're
violate,
also, you're
please
also,
let me,
but
sir,
listen,
you're
you just
interrupting me
made a
yet
rule.
again.
You just tried to put me under a rule that no one else was put under.
The circumstances require that I implement this rule, sir, given your
The
stubborn
circumstances
defiance
don't.
on
Your
the
Honor, that's
issue
a
of jury
prejudice to my
nullification.
defense. You can't place me under certain rules and not place the prosecution under the same rules.
Sir, the
It has to be
circumstances of
fair.
this case and your insistence on arguing jury nullification has resulted
I
in this
haven't-
court creating this rule.
I haven't argued it. I said that I wanted to inform the jury of their power. I never once said I'm going to make an argument. I'm going to give them a jury instruction.
You may not
never
advise
said
them
that.
or make them aware in any way that they have the power
And why
of
not?
jury
Why
nullification.
can't they be informed of their powers?
Because it would violate the Bajorkas decision, sir.
Violate what decision?
All right, sir, I am going to bring the jury out.
And I'm going to inform them that they have the power.
And if you do that, I will dismiss the jury and I will declare that your right to present
You
a
can't do
closing
that.
argument
Under what
has
lawful
been
law?
forfeited based
Then
upon.
I
She's
make
the
a
judge,
I'll bring
dummy.
that
oral
to
motion
date.
for
I'm
legal
not going
finding
to
of
declare
fact.
that at this point because I want to see what you will do. But if you raise the issue of jury nullification, I will immediately dismiss the jury. You will forfeit your right
You can't
to
do that.
Present a closing
Under
argument.
what lawful law can you?
And then if you continue to
Under
interrupt
what
me,
lawful law?
you will be removed to the other courtroom.
Look at the guy in the
as I
back.
complete
So I'm being
the
held in contempt
instructions.
again. Is it civil or criminal?
All right. Go ahead.
I apologize. May I ask the court to consider perhaps an alternative, and I fully respect the ruling the court has just made, and I understand the basis for it. We all know the defendant, in his petulance, will say jury nullification in the first 3 seconds the jury's in the room.
Objection
The-
to that.
Proper
I don't
thing
think
to
that
do,
I
I
should be
think,
talked
Your
down
Honor.
Stop
to.
interrupting
I don't
Attorney
think I
Hopper,
should be
please.
talked down to.
Allow him to make his closing argument. I will object if he misstates the law. You can instruct the jury to disregard any misstatements of the law. And we continue in that fashion, if possible, for a reasonable amount of time. And if it becomes to the point where there's no reasonable, legal, credible argument that's being made, then the court can decide as to whether or not he's forfeited his right to a closing argument. But we could at least try to, by merely objecting and the court telling the jury to disregard and instructing Mr. Brooks to move on to the next topic, we could try to allow him his opportunity to provide a closing argument. If that's unworkable, then I think this record will be very clear as to the efforts of this court. And I think there is materials in the bench book, or I'm sorry, the jury instruction 705 that talk about a jury instruction. This court could even give, telling the jury that they are not at liberty to disregard the law, but we're not going that far yet because, frankly, you have told them and you will tell them that closing arguments are not evidence. And I think they will abide by that. So I know it's going to require effort for the court to allow this to allow Mr. Brooks to try and proceed, but I think we should try that or something similar to that in an effort to get through this next step, or else we will continue at this pace forever.
I'm certainly willing to try that.
It's about all we could come up with, Your Honor.
I mean, I'm certainly willing to try it in this courtroom, and then if he disregards that, to excuse the jury and then have him present from the other courtroom would be the second step, and then third would be a forfeiture.
Agreed.
Your Honor, I object to that.
Your objection is noted for the record. That will be the course of action that this court takes. The first time you violate the rule, you may be subject to forfeiting your right to be present, where you will give the closing argument from the other courtroom. And if you continue in a blatant disregard of the requirement that you not reference in any way jury nullification, I may make that final determination outside the presence of the jury.
I object to that, Your Honor.
All right, with that, let's bring the jury
For the
out.
record, may I respectfully request the legal reconsideration of your ruling? So is that a tacit agreement that you don't have to answer my objection, Your Honor?
I decline to reconsider.
I reject that ruling and take exception to that ruling, Your Honor.
Noted for the record.
For the record, may I request a legal or factual basis for your ruling, Your Honor.
Denied.
For the record, may I respectfully request a written judicial finding of facts and conclusion of law on this issue, Your Honor.
Denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter.
I'm not the court to address that.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction, which this court has no subject matter jurisdiction.
Denied.
Under
The jury's
based on
coming
what
in.
law or
All
fact?
rise for the jury, please.
Based on what law or fact? Because I'm going to inform the jury of their power. They deserve to know.
The suspense is killing me. The suspense is killing me.
Thank you, everyone. Please be seated. Go ahead, Mr. Brooks, your closing argument, please.
Good afternoon. It's been a long day. First off, I'd just like to start by letting you guys know that it's a lot of information that you guys should be privy to, I believe. And one thing that I believe that you have not been privy to is the truth of your rights and your duties. Being the jury.
Oh no.
The fact that you and you alone have the power. Not well-prepared DAs with well-prepared and clearly rehearsed speeches and exhibits and a lot of theatrics. Frankly, not the judge. You and you alone have the power. You and you alone decide what is truth and what isn't truth. You should be informed that you have the power to nullify any law that you
Objection. Move to strike the statement.
Sustain.
Objection.
I will strike from the record the last statement made by the defendant. The jury will disregard it.
Which is clearly what I've been saying. I believe that not only is it fair, but it's essential that you be privy to all knowledge, not knowledge that certain people feel that you should hear and shouldn't hear, disguised under the color of law. The fact of the matter is, just like I did with my opening statements, I don't have a well-prepared or rehearsed speech.
You don't say.
I didn't look in the mirror and say certain points to myself over and over again to make sure I have them right or anything like that. I've chosen to speak from the heart in my opening statements, and now I'm going to speak from the heart. What you won't hear me do is argue facts. And the reason you won't hear me argue facts is because I believe that it takes away from what should be recognized. The tragedy of this event. It should be recognized. Trying to argue facts of this, facts of that, I'm not going to waste your time doing that. It's a little emotional. I apologize for the long pause. It's hard to keep everything together emotionally. And honestly, I don't believe that I have any more tears left. It's been a hard year for the families, mostly. And that should not be lost on anyone. It shouldn't be taken away. I said it before and I'll say it again. It's a lot of people that are healing, that are attempting to heal. That opens the door to talk about forgiveness for a little bit. With every healing process, there comes a forgiving process. It's not an easy thing for anyone. What you've been hearing from the prosecution, and not to take anything away from them, but let's call it what it is. You've been hearing a lot of rerun. Same things over and over and over. No different than when you turn on the radio and you first hear that song that you don't like when you first hear it, but they play it so much that eventually you start saying it, the words to yourself before you even realize it. And then you sit and you go, I hate that song. Why am I singing it? That's what's been happening. Rerun. Over and over and over and over and over and over and over. Attempting to make things stick in your head that simply aren't true. Why do I say, what am I saying? I say, look at the testimony. You know, the thing from the prosecution here has been intent, 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 intent. We all know what's been said. We all know the picture that's been painted. Even the prosecution said themselves. How can you look in somebody's head and say, this is what they intended to do? You know, for a year, I've sat and gone through this. Feeling so powerless. You know, letting other people run with the narratives. Sitting back helpless while other people paint a picture that has zero truth. Zero. I understand about healing myself, tragedy, pain, all that. A lot of it, there's no need to get into. I myself in my own life have had to do a lot of healing. As a man with children myself. I find it hard to believe that anyone who's really had conversations with me, spent time around me, would think for 1 second that this is an intentional act. I've never heard of someone intentionally trying to hurt someone while attempting to blow their horn. While attempting to alert people of their presence. Which brings me to more information that I believe that you should have been privy to.
Uh-oh.
And I'm sure that the prosecution will beg to differ. But the fact of the matter is, the vehicle in question, make and model of 2010, Ford Escape. The vehicle in question, actually 2008, 2009, and 2010 of that model was in fact recalled.
Objection, misstatement of the facts, facts not in evidence.
Was in fact-
Improper argument, Your Honor.
Sustained.
Was in fact recalled. Was in fact a class action lawsuit against Ford
Objection.
for those
facts not in
models,
evidence,
for
Your
those
Honor.
model vehicles.
Sustained. The jury will disregard.
Information that you should have been privy to, that you weren't allowed to be privy to. Why? I don't know. That information, malfunctioning throttle bodies,
Mr. Brooks, move on.
it's information that you should have been privy to. Vehicles that malfunction and accelerate not being able to be stopped.
Objection, that is.
It's
completely
information,
inaccurate,
it's
Your Honor.
information.
Objection. Hold on.
Strike.
Go ahead.
Move to strike statements by Mr.
Sorry for the
Brooks.
interruption.
They are facts not in evidence, Your Honor, and it's a complete misstatement.
Sustained. Strike
How's it a
the-
misstatement when I have the information?
Mr. Brooks, move on.
This is information that I feel like you needed to know. You should have known. Information that was taken away from you. Why? To prove a case? Information that you definitely should have been privy to. DA says the defendant has an utter disregard for human life. Utter disregard for human life. Not realizing that they're talking about someone that has children. Talking about someone that watched their children come out of the womb and be born into this world, cut the umbilical cord, held them before their mom even did. Moments that I'll never forget. And yet they say disregard, utter disregard for human life. They made reference to a rage as if they were, or if this particular DA was right there, standing right there, as if this DA is a psychiatrist. I said to myself, what, rage? What do you mean rage? How can you characterize that? How can you have the audacity to diagnose what someone's brain is, where it's at, what it's thinking, why it thinks the way it does? DA makes references to blocks of no one being injured, but then says it's intentional. You add that up with the supposed rage, the supposed intent to harm and kill, and it doesn't kick in until well within blocks. And maybe it's just me, but I would think if I was characterizing someone with this intent to kill and this rage and this anger, then why weren't people immediately harmed? Why would someone with intent to kill and rage try to alert people of their presence, repeatedly honk their horn? You heard a detective, if you recall, testify that the vehicle that he observed was not only honking his horn, but was not speeding. So where does this rage kick in? Where does this insatiable intent to kill kick in? They speak as someone who's known someone for years. Which brings me back to the vehicle. What if the vehicle couldn't stop because of the malfunction?
Objection, fact, not in evidence.
What if the driver of the vehicle was unable to stop the vehicle? Because of that fact, what if the driver may have panicked? Does that make the driver a crazed, or not crazed, a rage? Does that make the driver in a rage and intent on killing people? DA played exhibit 17. You don't see anyone struck in that vehicle. On that exhibit, you don't see anyone struck. Was someone who had this intent to kill, this rage, as she says. If that was their intent, wouldn't they have taken the opportunity to hit as many people as they could? Target people, mow down people. Reference was made to this vehicle, the damage. Says this was all caused by bodies, but then later turns around and says hits barricades and other objects. her testimony about hearing loud crashes and things of that nature. But the DA wants you to believe that this all came from people. Evidence doesn't support that. So I go back to trying to wrap my head around everything that's happened in the last year. Praying for those families, praying for the people that tragically lost their life, because that should not be lost either. The fact that there was lives lost, and all the emphasis has been put on the alleged defendant. And the people have been disregarded. Makes me wonder, does the DA even care about those people? There's been prayers going up every day. It's been suffering on both sides. It's been threats, hate mail. Because of the narratives that's been put out there, the misconceptions that have been put out there, the lies that have been put out there, lies that have caused my children not to be able to go to school, to be bullied, for my mother to have to leave her home and stay at a hotel because she's afraid for her safety, because she gets hate mail shoved through her mailbox. My nieces and nephews to fear for their safety.
You did that to them. Nobody else. Sorry.
And what's been equally hard is not only having to answer the questions from my daughter, who was 7 at the time, my baby girl, who was 7 at the time, is now 8. Attempting to answer her questions that she's asking, and still continue to shield her from what she sees, what she hears. Having a newborn son that I haven't even been able to meet. Haven't been able to hold, touch, kiss.
That's a good thing.
Having to navigate everything that comes with this whole situation. While still attempting to wrap my head around it. I can't honestly say how many times I've sat in my cell, especially during lights out, alone, where it's just you. And just been praying and asking myself, how could this happen? Not just for the people but for everybody involved, the community too. How could this happen? How? The hardest questions you can ask is those that don't have an answer.
He has 1 hour.
No matter how much thinking you do, no matter how much you try to look at it from different perspectives and
He knows the writing.
listen to other outside perspectives and listen to people that you trust and that you love,
He knows what's going on. It's over, brother.
still coming up with nothing. But to think for 1 second, one question I never had to ask was if this was intentional. That's something that I never asked once. Because I know it wasn't. As a matter of fact, it never even crossed my mind to even attempt to ask myself that, because I know it wasn't. And I know sometimes during this trial probably doesn't show. Maybe hard to believe. But trust me when I say no one outside of the families that had to go through this, no one's heart is more in pieces than mine.
He's saying he didn't do it on purpose.
So again, I go back to all these exhibits. Go back to everything that's been shown, everything that's been testified to. Everything you've heard.
Yeah, it's called
During this whole process, this trial.
Yeah, it's like a Southern thing, or
And again, I say
like
the same
Southern
thing
rap.
I said earlier. Same thing I said.
Uptown
in
New York, Bronx,
opening
Southside
statements.
Jamaica, Queens. You hear it.
I'm not reading from any paper.
It's because you can't
Brooks. Everything you've heard in opening statements, everything you're hearing now is from right here. Everything. You have the decision. You and you alone. All of you. You have the decision.
He knows he's cooked.
I'm sure you've taken a lot of notes during this process.
And this is it too, buddy. Like, you're done after this. You had your days.
Some days are longer than others. A lot of movement in and out of the courtroom for various reasons.
What do I know about the Bronx? Quite a bit, actually.
Remember the power that you have. Don't for 1 second let it be taken away from you. I can never understand the position of sitting on a jury in something of this magnitude. So I'm sure there's a lot of pressure. I pray that the right decision is made. The right decision. It's almost like that message.
I'm wearing out.
Well, not message, but that writing. When we're in our vehicles and we got that rearview mirror and
enjoy dinner
closer than they appear. But it's also another way of saying sometimes things aren't as they appear. I can't speak for anyone else, but me, myself, I believe in Jesus Christ.
Objection.
That's how I was raised. That's what I believe in.
I got up early for this. After going to bed late. Because of this.
None of us are perfect. But I try every day to make sure that I acknowledge him. That's why every time I step in this courtroom, I have my Bible with me everywhere I go. I even read it on breaks, recesses. This is not something that started at the beginning of this incident. This is something that has been instilled in me since I came out of the womb. This is how my family lives their life. This is how we was raised.
Hit the like button, please. Likey button. Somebody hit the likey button. Please, likey. We're not even at 100 likes. Like, what the hell? Come on. Get me over the 100 like mark. It's humiliating.
For whatever mistakes that I myself have made in my life, I've made peace with God. Made peace. I'm happy to say that my conscience is clear.
Why, thank you. Oh, that's good.
And because I believe, I trust him with my life.
Good, you're going to need to.
Nobody will never know why it was his will for this to happen.
Oh, no. Really? Can't you just leave God out of it?
A lot of lives were changed that day, mine included.
Oh, man. For what?
God's way is not our own.
I'll be sorry. You're welcome.
And no matter how much sometimes we want to question, we have to have faith.
Yeah, God did not allow that to happen.
Look inside yourself.
I mean, I don't feel that way about that at all. A lot of stuff happens that's bad.
Look inside yourself and make the right decision.
He could probably go on about his life, too. He wouldn't even care. Like, if they freed him, he'd get in trouble again.
Look inside your heart.
At least he's given a closing statement.
You have everything in your
Thank
hands
God.
now.
I was a little embarrassed for a while, but you guys hooked it up.
Everything.
Probably.
Do what's right. Do what's right.
Okay, you're done.
Don't let the smoke and mirrors take away your power. Don't let the theatrics take away your power.
As soon as he's done.
Each and every one of you has a decision.
Correct. This shows how competent he actually is.
Who's right?
Putting on a show. Yeah, they will. They will. I have faith.
Make the right decision.
I have faith. Yeah, he should get 6 life sentences.
It's hard to think about. My younger kids getting older and at some point having to explain everything to them.
I thought he was done.
Kids don't stay kids forever. And nowadays, kids is frankly a lot smarter than we were when we was kids.
No, when you
I'll tell you that much.
smarter than you. That's anybody.
I got a letter the other day. My youngest daughter. And she's still learning cursive right now, so She's the best writer when it comes to cursive. She'd rather print.
Why is she learning cursive?
She said, Dad,
You suck.
and this is from the letter. She said, Dad,
You suck.
why are people saying all these mean things about you? I haven't read the rest of that letter yet.
Because I can't read.
The rest of that sentence said,
I mean, it's got to be close, right?
that's not the dad I know.
You mean the one with the tattoo on his forehead?
Throughout this year, I've been called a lot of things.
Murderer, idiot, jerk off, loser, baldy,
To be
Frankenstein.
fair, I am a lot of things.
Ears are too low. Beard and hair are the same
Murder is
length.
not one of them.
Murderer.
Never has been, never will be.
It doesn't have a receding hairline. It has receded. It's not receding, it receded. He's got a receded
close
hairline.
my statements.
Oh, thanks.
Just want to say, open your hearts.
And this is why the judge did what she did, because he got his clothes. Somehow she managed to do this. She's
Go inside yourself when making this decision.
Thank you. Yeah, I mean, it certainly was from 1924. But the judge got what she wanted.
I have no fear.
Batman is here.
Pray and do what you know is right.
I mean, I can't believe she got this done. Good for her.
What you know is right. Think about everything you've heard. Think about everything you haven't been privileged to hear.
Uh-oh, here we go again. I'm a sovereign citizen. Jury nullification. I have a tattoo on my forehead. Is that evidence?
Think about the whole entire picture.
The one where you ran people over. That one. That's the one. Think about the whole video, really. Just be plowing people over. What are you looking at? Talk, dude. Come on. Wasting everybody's time. Oh, no. Josh is hangry.
And above everything, whatever you decide, make sure you yourself can live with it. Make sure you can live with it. That's the magnitude of the power that you have. Just like this tissue is in my hand, this is everything. You have everything.
Idiot.
Be at peace with what you decide.
Okay. We will.
Have no regrets. Don't let this decision weigh on you after it's over. Hopefully we got a lot of living ahead of us. Lord willing.
Moving on up to the east side. Now we're up
back and kick yourself in the behind.
in the big leagues. It's our turn at bat. As long as we live. Got a lot of living. Time's up.
About 3 weeks with you.
Oh, it's been a delight.
Took a lot of courage and a lot of guts to pause your life for this.
They didn't really have much of a choice. It's called a jury summons.
To put important things on hold. To basically stop your life. You should be commended for being able to sit up here
That's what I was
with
thinking.
this amount
Jamie.
of pressure.
Yeah, she did pretty. I mean,
I want you guys to know that's not lost on me. I'm sure it's a lot. And you all should be commended because it took courage to do this.
right.
I don't know, but I would bet a lot of people wouldn't want to be sitting in your position right now.
Right.
And
Now
you guys
we're
have the
up.
guts to do it.
Oh, God, here we go. Here we go with the sovereign citizen jury nullification.
Thank you for that. Thank you for taking
No,
pretty much a
unfortunately.
month and setting it to the side for this. It's probably not proper, but you guys deserve a round of applause if you could get one. Thank you guys sincerely, and I know, and I have faith, and I trust that you guys know what's right.
Yeah.
Ladies and gentlemen, I don't think it's fair to just say guys, but
I mean, this is it for him. He knows it's it. Bum, 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 bum.
I believe in your heart you know what's right.
Okay, you've said that 17 times.
Thank you.
All right, that's it. Cut him off. Turn his mic off. Oh, he's going to cry like a
Biatch!
biatch.
Opportunity. To
Biatch! Sorry if I cuss.
stand for a
But
minute.
that's what he is. He's a biatch. Ugh. Sick.
All right, have a seat, please. And Attorney Opper, I did time both closings. You have 13:28 left.
Thank you, Judge. I don't think that'll be an issue. Folks, let me just say this. Mr. Brooks stands here and professes to speak to you from his heart. He plays on your sympathy. He talks about his children. He talks about the hardships that he's encountered and his family's encountered. And he brushes over the loss to the community. He wants to talk about how he's never held his newborn son. Never once acknowledges the Sorensen family, the Owen family, the Duran family, the Hospital family, the Kulik family, the Sparks family. Never once. It's nice that Mr. Brooks can get letters from his loved ones.
Yeah, it's nice. Exactly.
I don't know why he did this. I told you that.
But it wasn't an accident.
But actions define a person. It's that simple. You can stand with the Bible in your hands all day long and profess to be the finest man under God that you can be. But when you drive through a parade route and roll over children with band instruments to the extent that your vehicle heaves up and down, your intent is known, Mr. Brooks. It doesn't have to be guessed. It's known.
You cannot address him that
You
way.
don't have to stand and wonder as he claims to.
Yeah, she's good stuff, man. Get it.
For him to keep going after he drove over those children in the band and have Jackson Sparks fly off the front hood of his car, lifeless, and keep going. And have Jane Kulik fly off the hood of his car, run her over, and keep going. I'm not going to go on. You get it. You need to look in the mirror, Mr. Brooks. If you want to accuse me of practicing my closing argument, you need to look in the mirror, sir. Your actions are that of a murderer. You murdered these 6 people. You endangered the safety of 61 others. There are 68 victims in this case, folks. That's not an accident. That's not a, gee, I woke up one day and don't know how I found myself in this position. If you have some explaining to do to your children, Mr. Brooks, I recommend you do it.
Oh! Oh! Oh!
Now, members of the jury, the duties of the parties and the court have been performed. Wow. The case has been argued by the parties. The court has instructed you regarding the rules of law which should govern you in your deliberations. The time has now come when the great burden of reaching a just, fair, and conscientious decision of this case is to be thrown wholly upon you, the jurors selected for this important duty.
That's like
You will not be swayed
a
by
verbal
sympathy,
bitch slap.
prejudice, or passion. You will be very careful and deliberate in weighing the evidence.
Oh, man.
I charge you to keep your duty steadfastly in mind and as upright citizens to render a just and true verdict. You are to decide only whether the defendant is guilty or not guilty, of the offenses charged. Any consequences of your verdict are matters for the court alone to decide and must not affect your deliberations.
That was
the following
epic.
76 forms of verdict will be submitted to you concerning the charges.
God bless
against
her.
the defendant, Darrell E. Brooks. Count 1. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 1 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 1 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 2. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 2 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 2 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no.
We've got to do this again.
Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 3. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 3 of the information.
I'm going to need
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 3 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 4. Excuse me.
Oh.
Count 4. Count 4. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 4 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 4 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 5. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree intentional homicide as charged in count 5 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 5 of the information.
It really was.
If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon? Count 6. One reading, we the jury find the defendant, Darrell, charged in count 6 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree intentional homicide as charged in count 6 of the information. If you find the defendant guilty of first-degree intentional homicide, answer the following question, yes or no. Did the defendant commit first-degree intentional homicide while using a dangerous weapon?
Yes.
Count 7. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 7 of the information.
Guilty.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 7 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 8. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 8 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety.
Oh, he's guilty.
If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 9. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 9 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 9 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
There's no way. I mean,
Count 10. One reading,
can't be.
we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 10 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 10 of the information. If you find the defendant guilty of
Who
first
wants it
degree
back?
recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 11, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 11 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 11 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 12, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 12 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 12 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 13, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 13 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 13 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 14. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 14 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 14 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 15. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 15 of the information.
I don't know how many times you got to do it.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 15 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
I thought we went through this already.
Commit first degree recklessly endangering safety while using a dangerous weapon? Count 16.
They
One
took his
reading,
boxes
we the
from
jury
him.
find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 16 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 16 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
No.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 17, one reading. We the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 17 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 17 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 18, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 18 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 18 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
Yes.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 19. One reading,
It's like she
we the
can't hear
jury
me or
find the
something.
defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 19 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 19 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety?
I might
while
do
using
that
a dangerous
actually.
weapon? Count 20. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering
curious
safety
about his
as
interrogation.
charged in count 20 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 20 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 21. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 21 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 21 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
No.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 22, one reading.
I'm losing
We, the jury,
steam here,
find the
folks.
defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 22 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 22 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 23. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 23 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly.
I mean, yeah, that's probably not a bad idea to mute her. I mean, he's going to be found guilty. I don't know. There's so many counts. Like, they got to go through them one by one. But do they got to go through them all one by one? Do they got to? See. Do they got to go through them? It's just one by one. One by one. Oops.
Count 25. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of
Sweet.
first
Corn
degree
dogs for
recklessly
everyone.
endangering safety as charged in count 25 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 25 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 26. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 26 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 26 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 27. One reading. We, the jury, find the defendant.
There's like
Darrell E.
67,
Brooks, not
61?
guilty
I don't know.
Of first degree recklessly endangering
There's a
safety.
ton.
Charging count 27 of the information. Another reading. We, the jury, find the defendant,
Pretending to
Darrell E. Brooks,
read the Bible.
guilty of first degree recklessly endangering safety as charged in count 27 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 28. One reading,
Oh
we the
my
jury
God.
find the defendant, Darrell E. Brooks,
Not even
not
halfway
guilty
there.
of first degree recklessly endangering safety as charged in count 28 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 28 of the information.
It will
If
be
you find the defendant guilty of first degree
much more
recklessly
exciting
endangering safety,
when
answer the following
they
question,
read
yes
them
or no.
off.
Did the defendant commit first degree
And we'll do it
recklessly
live.
endangering safety while using
We'll make a
dangerous
whole
weapon?
spectacle
Count
out of it
29,
because
one reading,
I feel
we
like
the
there's a
jury
lot of
find the
guilties
defendant,
on the way.
Darrell E. Brooks.
There's a lot of guilties on the way, so there'll be flares and objections and box forts, friggin' everything.
As charged in count 29 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 30. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 30 of the...
I may get streamers and like little pew. I might fire off a real flare gun. I might. It's a possibility.
recklessly endangering safety. Answer the following question, yes or no.
I gotta go to the joke
Did
store.
the defendant commit
But I might go.
first-degree
I might
recklessly
have a
endangering
flare gun.
safety while using a dangerous weapon? Count 31. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety.
Can you
as charged in
imagine?
count
I
31 of the
if I could
information.
fire one off in here.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 31 of the information.
I might do it.
If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 32. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information. That should be 32. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count...
Jennifer's new to the
32.
lab. Are corn dogs our preferred snack?
of the information.
I don't know if they're our
If you
preferred
find the
snack,
defendant
but
guilty of first
maybe.
degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? We're going to have you take a short stand break while I confer with Madam Clerk.
Come on, dude. Are you kidding me?
This is 32. So
Son of a gun.
this will need to be corrected. So I need to reprint that.
Okay, well, you could read one twice and then I'll make another one. Starts with page 88. Got it.
Yeah, corn dogs are good. Boing da dong da dong dong. Check this out. If anybody's ever watched the Howard Stern show, there's a little guy on there. His name was Eric the actor. And they would always try and get him to fly with balloons. He never would. Unfortunately, he passed away, but gave us hours and hours of entertainment. Eric the actor.
When you're ready, have a seat.
Okay, we're back. Thank you, Linda, for that
Count
gift.
33. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 33 of the information.
Yeah,
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 33 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 34, one reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 34 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 34 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 35. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty.
No, Lex, no, she's instructing the jury.
Of the information.
She's just instructing the jury that these are the counts and that these are the options.
Endangering safety as charged in count 35 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 36. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 36 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count
and Love Pink,
of the information.
I know you're out there watching. Thank you for the $30 PayPal. Very, very generous of you. Thank you. And I hope you're feeling better as well, but thank you for that.
Dangerous weapon. Count 37. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 37 of the information.
It will be used for
Another
iced
reading,
coffee and corn
we,
dogs.
the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 37 of the information. If you find the defendant
something for
guilty
Macho
of
and Otis,
first-degree
too.
recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 38. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 38 of the information.
60-something.
Another reading, we the jury find the defendant.
Look, it looks like
Darrell
he's
E. Brooks,
sitting right
guilty
next to them.
of first-degree recklessly endangering safety as charged in count 38 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon? Count 39. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 39 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first-degree recklessly endangering safety as charged in count 39 of the information. If you find the defendant guilty of first-degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first-degree recklessly endangering safety while using a dangerous weapon?
Crap.
Count 40. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of first-degree recklessly endangering safety as charged in count 40 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty.
Another thing that the prosecutor or the district attorney said, and by the way, you know, these people are 10 times smarter than me ever, so I know exactly what she was saying, and there was a reason for it. But when she said like 68 people's lives were changed that day, I would disagree. I think thousands, if not hundreds of thousands of people, like, you know, are going to think about that every time they go to a parade, every time they go, you know, where there's a big gathering and cars are going down the street. It's not, to me, I get that he's on trial for what he did to these people, but like, he shouldn't have been, but technically he could be charged with how many counts of attempted murder?
Count 42. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 42 of the information. Another reading, we the jury find the defendant,
Yeah, the Bible.
Darrell E. Brooks,
Where did
guilty
you? No,
of
well,
first degree
I saw
recklessly
that. I
endangering
was
safety
gonna
as charged in count 42 of the
say
information.
something.
If you find the defendant guilty of first degree recklessly endangering safety,
Yeah,
answer the
I
following
agree with
question,
this.
yes or no. Did the defendant commit first degree recklessly endangering
I agree with you,
safety
Noel.
while using
His
a
Bible
dangerous
thumping is
weapon?
disgusting. He played God himself
Count 43.
and unalived so many
One
of
reading,
God's children.
We, the jury, find
Sounds
the
more
defendant,
like the
Darrell
devil.
E. Brooks,
You're right
not
about
guilty
that.
of first degree recklessly endangering safety as charged in count 43 of the information. Another reading, we the jury find
Absolutely
the defendant,
it
Darrell
does.
E. Brooks, guilty of first degree recklessly endangering
I mean, this was a
safety as
terrorist
charged in
act.
count 43
I'm not
of the
saying
information.
like
If you find the defendant
that's the
guilty of
definition
first-degree
is to cause
recklessly
terror,
endangering
to
safety,
disrupt daily
answer the
life, and that's what he's
following
done.
question, yes or no.
He has disrupted daily life by instilling fear into
We the jury find
people everywhere. It's like the Aurora shooting with James Holmes.
one of the information.
How many people stopped going to the movies because of that? A lot.
Guilty of first degree recklessly endangering safety as charged in count 44 of the information. If you find the defendant guilty of first degree recklessly endangering safety,
I'm giving you everything
answer
I
the
got,
following
folks.
question, yes or no.
I got. It's like
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 45. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 45 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 45 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 46. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 46 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in
I think
count
about
46.
I think about that too. You know, like you go in a theater or something like that, and that thought shouldn't pop into your mind, but sometimes it does, and you're like, wow, if somebody walked in here right now and started doing what happened there, like we got a big problem.
Not guilty.
It's
of
gonna
first-degree
be
recklessly
devastating.
endangering safety.
Shouldn't
as
have
charged
to
in
think
count
about that
47
kind of
the
stuff, but you
information.
do.
Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 47 of the information. If you find the defendant guilty
Yeah, it's gonna
of
take a
first
long
degree
time.
recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety
He's behaving
while using
himself.
a dangerous weapon? Count 48. One reading, we the jury find the defendant, Darrell E. Brooks,
They
not
for
guilty
sure are.
of first degree recklessly endangering safety as charged in count 48 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 48 of the information. If you find the defendant guilty of first degree recklessly
He's guilty.
endangering safety, answer the following question, yes or no.
Yes.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 49. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 49 of the information. Another reading,
You're not
we, the
missing
jury,
much. He's
find
just
the
being a-
defendant,
he's just being a
Darrell E.
turd.
Brooks, guilty of first degree recklessly endangering safety as charged in count 49 of the information.
That right there is
If
the
you
third
find the
yawn
defendant guilty of
in like
first degree
3
recklessly
minutes.
endangering
That's not.
safety, answer the following question, yes or no.
Yeah, we're
Did
close.
the defendant commit first degree recklessly
Crappy,
endangering safety
boring.
while using a dangerous weapon?
Talked about his kids.
Count 50. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 50 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 50 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly
I don't know.
endangering safety while using a dangerous
4
weapon?
hours now,
Count
probably.
51. One reading. We, the jury, find the
And then
defendant,
what did I
Darrell
do,
E.
like,
Brooks, not guilty
how long was
of
this
first
morning?
degree recklessly endangering safety as charged in count 51 of the information. Another reading. We, the jury, find the defendant, Darrell
So
E.
about
Brooks,
5
guilty of
hours.
first degree recklessly endangering
and 22
safety
minutes.
as charged in count 51 of the information.
Yeah.
If you find
Long
the
time.
defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit
I can't
first
quit. I
degree
can't give
recklessly
up.
endangering safety while using a dangerous weapon? Count 52.
Darrell
One
the
reading.
third.
We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 52 of the information.
I never
Another reading,
streamed
we, the
this long,
jury,
but
find the
hey,
defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 52 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 53. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 53 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree
Well, thank
recklessly
you,
endangering
Plano.
safety as charged in
Appreciate that.
count 53 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
I figured I'm gonna
Count
watch it
54.
anyway.
One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty.
Plus, I
of
like
first
to
degree
entertain when I
recklessly endangering
can.
safety as charged in count 54 of the information.
Some would say I'm not
Another
entertaining at
reading.
all.
We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 54 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 55. One reading. We, the jury, find the defendant,
The eyes are
Darrell
burning.
E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 55 of the information.
There go the eyes.
Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 55 of the information. If you find the defendant guilty of first
I'm gonna
degree
finish this.
recklessly endangering safety, answer the following question, yes or no. Did the defendant commit
committed.
first degree recklessly endangering safety while using a dangerous weapon? I think I'll give my jurors one more stand break before I conclude. So please stand and
I
anyone
just
else in
got
the
something
courtroom.
here on a Cash App. Jennifer? I don't want to say her last name, but like I do, but I'm not going to. Which one?
If you want these.
Oh, I will. I slept a little last night, like 4 hours.
Oh, yeah, I did.
But then I just kept thinking about this trial, and I was like, I woke up and I was like, oh my God, this is going on right now. I got to see it. I got to see it. I got to see it. I don't
Thank
know.
you. Have a seat.
I don't know what charges were on. I don't even care anymore.
Count 56.
Jennifer,
One
thank
reading.
you for
We,
the
the
Cash
jury,
App.
find
I
the
appreciate that.
defendant,
$20 on the
Darrell
Cash
E.
App. Thank
Brooks,
you.
Not guilty of first degree
Very much
recklessly
appreciate
endangering
it.
safety as charged in count 56 of the information. Another reading. We, the jury, find the defendant, Darrell E. Brooks, guilty of first
Yeah, I'm gonna
degree
take a nap
recklessly
with those
endangering
boys.
safety as charged in count 56 of the information.
They're so
If you find the
cute.
defendant guilty of first degree recklessly endangering safety, answer the following question, yes
Yeah,
or
I
no.
got you.
Did the
you.
defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 57. One reading. We, the jury, find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 57 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 57 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following
Corn dog
question,
time.
yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous
Oh,
weapon?
Patty. You don't have to. I'm just glad that you're here.
Count
I appreciate
58.
it.
One reading, we
Commenting
the jury
and
find
talking.
the defendant,
I love
Darrell E.
that.
Brooks, not guilty of first degree recklessly endangering safety as charged in count 58 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 58 of the information.
You don't
If
have
you
to
find
feel
the
sorry
defendant
for
guilty
anything.
of first degree recklessly endangering safety, answer the following question,
I totally
yes or no.
understand.
Did the defendant commit first degree recklessly endangering safety?
I'm glad that
while
you're
using a
here and
dangerous
chatting.
weapon?
I appreciate it.
Count 59. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 59 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 59 of the information.
No, I'm not.
If
I'm
you
not
find
really
the defendant
hungry.
guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 60. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 60 of the information.
Yes.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of
You know what it was that took a lot out of me? I think what took a lot out of me was the whole, you out of order. You out of order. I'll show you out of order.
Following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Out of order.
61.
Took a lot out.
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 61 of the information. Another reading, we the jury
I'll show
find the
you out of
defendant,
order.
Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 61 of the information. If you find the defendant guilty of first degree recklessly endangering
like
safety,
SpaghettiOs, too.
answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety?
You out of order.
while
I'm
using
out
a
of order.
dangerous
We're all
weapon?
out of order.
Count 62. One reading, we the jury find the defendant,
Lily,
Darrell E.
Lily,
Brooks,
how
not
was his
guilty of
closing? It
first
sucked.
degree recklessly endangering safety
But, like, he
as charged in count
it-
62 of the
it was just a little
information. Another reading,
crybaby.
we the jury find the defendant, Darrell E. Brooks, guilty of first degree
I don't know, it's the
recklessly
31st,
endangering
so
safety as charged
what's
in count
today?
62 of the information.
30th or 31st.
If you find the defendant guilty of first degree recklessly endangering safety, answer the following question,
1,
yes
2,
or no.
3, 4,
Did the
5,
defendant
6,
commit
7.
first degree recklessly
Yeah.
endangering safety
It's like
while
7
using a
days.
dangerous
You out of order.
Count 63. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 63 of the information. Another reading,
I'll show you
we
out
the
of
jury
order.
find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 63 of the information.
Awesome.
If you find the defendant guilty of first degree recklessly endangering safety,
Yep.
answer the following question, yes or no.
Yes.
Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 64. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree
Nice.
recklessly endangering safety as charged in count 64 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 64 of the information.
Yes.
If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 65. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 65 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 65 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no.
Yeah, that cop wants
Did
to
the
punch him.
defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 66.
What did he say if
One
this was
reading,
20?
we the jury
What did he say if this was 20 years ago? I'd take a flamethrower to this place.
degree recklessly endangering safety as charged in
I'm too old,
count 66
too tired, too beeping blind.
of the information.
There is no prosthetic for an amputated soul.
I'll just repeat count 66. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 66 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 66 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon?
Yes.
Count 67.
Is this it?
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of first degree recklessly endangering safety as charged in count 67 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of first degree recklessly endangering safety as charged in count 67 of the information. If you find the defendant guilty of first degree recklessly endangering safety, answer the following question, yes or no. Did the defendant commit first degree recklessly endangering safety while using a dangerous weapon? Count 68.
Is this the last one?
Reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 68 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 68 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Virginia Sorensen?
Bum, bum, ba.
One reading.
We are the
Darrell E. Brooks,
champions.
not guilty of hit and run as charged in
Champions.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 69 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Leanna Owen? Count 70. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 70 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 70 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no.
No.
Did the accident cause death to Tamara Durand? Count 71. One reading, we, the jury, find the defendant, Darrell E. Brooks, not guilty of hit and run, as charged in count 71 of the information. Another reading, we, the jury, find the defendant, Darrell E. Brooks, guilty of hit and run, as charged in count 71 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Jane Kulik?
Yes.
Count 72. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of hit and run as charged in count 72 of the information. Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of hit and run as charged in count 72 of the information. If you find the defendant guilty of hit and run, answer the following question, yes or no. Did the accident cause death to Wilhelm Hospital? Count 73.
Somebody said 72. We're on 73 now?
Darrell E. Brooks,
oh my
not
God.
guilty of hit and run as charged in count 73 of the information. Another reading, we the jury find the defendant, Darrell E.
You gotta
Brooks,
be joshing me.
guilty of hit and run as charged in count 73 of the information. If you find
What's
the
that?
defendant
That sounds
guilty
good.
of hit and run, answer the following
What's a
question,
Shack
yes
pizza?
or no. Did the accident cause death to Jackson Sparks?
Is that like a
Count
Papa
74.
John's?
One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in
Okay, the numbers
count
keep going up,
74
and I don't
of
know why.
the information.
I feel I've been...
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of bail jumping as charged in count 74 of the information. Count 75. One reading, we the jury find the defendant, Darrell E. Brooks, not guilty of bail jumping as charged in count 75 of
I
the
cussed a
information.
lot, actually.
Another
Like,
reading,
I didn't-
we the
I didn't say
jury
any
find the
Fs, but-
defendant, Darrell E. Brooks, guilty
Shack
of bail
pizza.
jumping as charged, in count 75 of the information. Count 76. One reading, we the jury
I'm
find the
shocked.
defendant, Darrell E. Brooks, not
Me and
guilty
Kobe,
of battery.
it was the
as
best
charged
duo
in
ever.
count
I'm
76
shocked.
of the information.
My name's Shaq.
Another reading, we the jury find the defendant, Darrell E. Brooks, guilty of battery as charged in count 76 of the information. It is for you to determine whether the defendant is guilty or not guilty of each of the offenses
guilty, Your Honor.
charged. You must make a finding as to each
He's as
count
guilty as
of the
Barkley is being
information.
fat.
Each count
Guilty,
charges
guilty.
a separate crime, and you must consider each one separately. Your verdict for the crime charged in one count must not affect your verdict on any other count.
Better pizza, better
This
prices.
is a criminal,
Papa John's.
not a civil case. Therefore, before the jury may return a verdict which may legally be received, the verdict must be reached unanimously.
Shack Pizza
In a
has
criminal
extra
case,
cheese,
All
pepperoni.
12 jurors must
and it's
agree
big.
in order to arrive at a verdict.
Okay, we got there.
When you retire to the jury room, select one of your members to preside over your deliberations. The presiding juror's vote is entitled to no greater weight than the vote of any other juror.
I'm Shaq.
If you need to communicate with the court while you are deliberating, send a note through the bailiff signed by the presiding juror. To have a complete record of this trial, it is important that you communicate with the court only by a written note. If you have questions, the court will talk with the parties before answering, so it may take some time. You should continue your deliberations while you wait for an answer. The court will answer any questions in writing or orally here in open court. When you have agreed upon your verdict, have it signed and dated by the person you have selected to preside. After you have reached a verdict, the presiding juror will notify the bailiff that a verdict has been reached. Everyone will return to the courtroom. The verdicts will be read into the record in open court. The court may ask each of you if you agree with the verdicts.
Unreal.
Before I
Shaq.
swear the officers, we will determine the alternates, and then I will have all of the civilian bailiffs and deputy bailiffs that will be in charge of the jury during their deliberations and sequestration.
Wait, hold on.
Yeah, let's put it over here.
Okay.
I have a lot of stuff up here.
Hey, hey, goodbye. Na 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 na
You guys hear that?
na 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 na. Hey, hey.
So we have placed each one of your numbers in the tumbler. I'm going to draw 3 numbers. Those numbers will be alternates, who will nonetheless be sequestered in the event we would need to call upon one of you to replace another juror. The first number that I am pulling out is 10. The second number I am pulling out is 30. The third number I am pulling out is 1. I want to confirm that I still have 12. I know Madam Clerk did it, but I will also do that to be sure.
At least one of us is happy about it.
But the other 12 numbers were in there. I'll put those back in and then we'll make a record of that. All right, then I will need all of the deputies and civilian bailiffs to come up and be sworn on the record for the sequestration and
I just want him to get tased.
Clerk of Court Paz, why don't you join them just in case you're needed?
Yeah, we're going on 4.5 hours now.
All right, would you all please raise your
Closing arguments, really. Ankle shocks, and apparently they shocked his balls or something. Somebody said that. Might have been me, I can't remember. And it's probably not true at all.
To them yourself, except to ask whether they have
But it made me feel better.
verdict, and that you will not, before they render their verdict, communicate to their deliberations or the verdict they have agreed upon, so help you God. All right, and then Madam Clerk will just make a record.
Prison
of
nickname
who you all are.
rollover.
It will take us a moment just to have all the finalized paperwork to go back with the jury. I do have
Yeah,
all the
it was
verdict
me.
forms, if I want to give that to
The ball shock. I honestly I think you need take a cattle prod and just, yeah. You know what I mean?
All right, and here are the jury instructions as well. For the record, it's 6:24. All rise for the jury as they're excused to begin their deliberations.
Sweet.
We'll make a record of what she did previously. But
Yeah, I'm gonna need all of them, and then I'll
Yeah,
take
no, I
them
know.
down and all
But
that
those are
good
the-
stuff. Yeah.
I'm not. No, I'm not.
Is that close? All right, thank you. You may be seated.
Taser his
Just
ass.
so the record is clear, the alternates, of
All
course,
right.
will
I
not
think
be
we're done.
Participating in the deliberations.
I think
They
we're
will
done
be
for
in
the night,
separate
or for
jury
until at least they
deliberation
come back. I don't know when they're coming
room,
back.
And will only be called.
Gotta cover it
if
though, right?
Needed, of course, after.
I'm guessing tomorrow.
The parties.
At least I hope
As
tomorrow.
far as how late, I will let them deliberate tonight. We have ordered dinner for them. I believe it will be here shortly.
Well, they're good for
And
dinner.
I really will leave it up to them as to how late they want to deliberate before they would want a break and then to retire for the evening.
We
They
want a
are
break.
under a sequestration order, so they will be kept separate and apart. Their electronics have been confiscated, and they will not be going home until verdicts have been reached or they are discharged from the court, whichever would occur sooner.
Shoot, we don't do that over here.
Anything else the parties would want me to address at this moment from the state?
Thank you, Judge.
Anything from you, sir?
Yep.
Oh shit.
So essentially, all I go back to my unit, use the phone, shower. It is shower day for my pod. We only get 2 shower days.
I don't. So here's what could happen, though, sir. I don't have a problem with you doing that, but they could have questions, and then you would need to become available so we could address any questions they may ask for exhibits, things of that nature. So as long as you're willing to come back for those things, I don't have an issue if, you know, I probably should talk to the COs or at least the sheriff and make sure I'm not stepping on their toes since they're in charge of all of that. But it's possible that we get a request for exhibits.
Shower day in my
Some
pod.
exhibits initially I wouldn't be surprised if we got that. So let me do this. Let me confer with the sheriff's department. I don't initially see an issue with that, but I want to make sure that they have a protocol in place and that's what they would like to do as well, okay?
And one more thing.
Go ahead.
I was curious. 61 charges for the reckless. 61 injured parties did not testify. So how does that work?
It's over, dude. Shut up.
Essentially, how are charges able to be charged if all of the injured parties did not testify?
From my perspective, sir, the state presented their theory of the case, and there was sufficient evidence regarding the charges to go forward to the jury. I can't further explain it from there because that would require me to explain the law. And I guess that's all I can really say about it at this point.
I got a point, though.
I'm sorry?
I got a point, though.
Yeah, it's on the top of your head.
I'm not going to comment on that, sir. Of course, the state bears the burden of proof, and they have to convince a jury beyond a reasonable doubt. For better or for worse, sir, I was not presented with any motions to dismiss, either at the end of the state's case or the close of the evidence, regarding any legal arguments you may have had regarding those issues. And so at this point, the jury has the case, and they will determine their verdicts. If there are issues of law that you want to raise after the verdicts are received, then you'll have to make that determination.
Yeah, that has to be raised because essentially you can't, if no injured party testifies, then it shouldn't be a charge.
I disagree with that characterization, sir, but there is frankly no motion in
Order!
front of me based in law or fact, so for me to comment any further would require me to give an advisory opinion, which I'm not willing to do.
So you're saying I need to make a motion?
So what I will say at this point is I do have
Excited.
one issue that I would like to raise with the parties.
I thought you wanted to shower.
I frankly I need a break a little bit. I mean, obviously the court has to stay open. I know my dinner is coming.
Yeah.
And I think it's reasonable. I need to put a few things together, but I do need to make a record of some information that I received earlier today so that the parties are advised of that. But I will do that. Let me confer with the Sheriff's Department about your requests. I'd like to take in about 30 minutes, address the issues that I need to address, or the issue. And I want to find out if that would interfere with your request about taking a shower and all of that. So if you can hold tight and stay with us for a little bit, that would be great. And I'll confer with the Sheriff's Department and have a more definitive answer for you shortly, okay?
Can I get my filings?
Idiot.
You want the originals back. If Madam Clerk has scanned them all in and they're uploaded, I don't have an issue giving you the originals back.
Oh, thank you very much,
They will
Lisa.
have the date stamp. They don't have a time because they were filed in court.
Appreciate that.
When he put the time on, I also, so that you knew they were in there, printed them after I scanned them in, so it has a document number.
So you're getting 2 copies. So you'll have that, okay?
See? I didn't interrupt you, see?
I'm sorry?
I said, see, I didn't interrupt.
I mean, he is
Thank you, I appreciate that.
he is manic, dude.
Unless there's, I would like the parties back in about a half an hour. Thank you, unless they have a question sooner.
He is manic.
Your Honor, do I have to go in that holding cell or do I get to go?
Wow. What is wrong with him? It's like a teacher. Like he was like he's like the kid that's like a dick to the teacher, and then all of a sudden, dude, that guy is weird. It's nothing to be happy about. I'll catch you guys later. Thanks for being here. I appreciate it. I don't think that they'll come back tonight, but if they do, they do. And we'll do it live! We'll do it live! You're out of order! You're all out of order! I'll show you out of order. I'll show you out of order. You're out of order. Oh, where the wind blows. Thank you so much. Appreciate that. $3 super chat. Out of order. Had a good time, guys. Thank you.